Heyo, and just got back from work. Uh, mm, it seems like today haven't started yet. Because why would it? Why would George Glanville choose to be on time this day of any day? So, while we wait, let's look at the final thing that happened Wednesday. Because yeah, there was some commotion. Hello, Mr. Jingles. Hello, Mr. Jingles. Oh, he's yeah. Yeah, let's have a look at it. There.
Go ahead and just as an opening kind of to the court's addendum, just tell you that I'm only going to consider the statement and want to hear argument as to whether or not it falls within 24-8-801 D2A, because from doing a little more research, if it's an admission against interest and the statements in a criminal case, and this is the case law, and I'm looking at Anderson versus the state, 360 Georgia App 291. If it's in a criminal case, exposes that the declarant to criminal liability is showing must be shown of the corroborating circumstances that clearly indicate trustworthiness of the statement. So my original ruling would stand on that issue, that you'd have to be able to show where it came from, even though generally a repost can't be changed, but I don't know that. So I would have to hear something about that. So I'm not going to take it as a statement against interest. I will, however, hear any argument as to whether or not it still falls within an admission by a party opponent.
Does the court have a preference for when each side speaks?
Okay, go ahead.
So, Your Honor, under 24-8-801 D2A, admission by a party opponent, I believe the question raised was whether it was an admission. 24-8-801 defines statement as an oral or written assertion. In this particular case, there was an oral assertion that if you lie to your folks and get in court and tell the truth, you need to be killed. That's from me and YSL. But 24-8-801 also defines a statement as nonverbal conduct of a person. The nonverbal conduct was capturing himself saying that, memorializing the assertion, the oral assertion that he made. So the exhibit itself qualifies as a statement because it contains both oral assertions and nonverbal conduct. And so therefore, under 24-8-801 D2A, it is a statement of a party opponent, which is admissible without the presentation of any predicate or foundation. Additionally, Your Honor, 24-8-801 D2E would make anything said by the people behind him who are co-signing as to what he is saying, co-conspirator statements. They are literally—
We don't know who they
right.
are. So
right. And so what we hear happening by the primary and only relevant speaker, and that being the defendant Williams, is as he is saying, y'all need to get killed, bro. That's from me and YSL. There's no rejection or rebuking or anything like that of the snitching bitching statements. So essentially, he's adopting those as his own as well.
He being Mr. Williams, so purportedly, right?
Yes.
Okay.
And so we primarily stand on the admissions by a party opponent. And as to the commentary that is also heard, we would argue that Mr. Williams has adopted those, and that any argument to the contrary goes to the weight and not the admissibility of the statements. And the jury is a proper entity to weigh that statement.
All right, madam.
Thank you.
Mr. Steele?
Oh, hello, folks.
I found a case, it's United States versus Rodriguez, which is R-O-D-R-I-G-U-E-Z.
One more time.
Yes,
Is
sir.
it RODRIGESZ?
While we wait, we are watching the final
R-O-D-R-I-G-U-E-Z.
Yes, sir.
And it's 427.
final half hour
Ben,
of
which is FED
Wednesday
period, appendix
before they went
APX
on a
period,
bit of a break.
784.
One more time, I said
Yes, sir. 427.
427?
Ben,
I'm
FED
sorry.
period, appendix, APPX period.
You said bed, appendix?
Yeah, FED period, APPX period. 78.
This is when they argued about, is this party admission going to be allowed? With Mr. Williams looking into the camera and say something of the sort of YSL is going to take care if you snitch, something of the sort. It is quite bad. Don't say stuff like that on a camera. Don't. Now, according to Georgia rules, if the judge says it's a party admission, then you don't have to lay foundation. And here's the switch in the prosecution. For the prosecution wanted to show it as a impeachment reason for the last snitch. And just after he ruled, they came up with a new idea. Oh, party admission, which blindsided the defense. And the judge gave them 10 minutes to prepare. And Mr. Steele still found case law from 11th Circuit, which local Georgia decision bastardized, in my opinion, because there is nothing evidentiary, in my opinion, should ever be able to be laid without the foundation for it. But welcome to Georgia.
4.
All right.
It's in division
Let me see if I can find it.
C1.
Hold on 1 second.
Do you remember when the judge said he would start at 8:45 at Mondays? Apparently not. I'm going to see with Kathy
It looks like it's
Russon.
2011. Is that correct, Mr. Steele?
Correct. May 25, 2011.
That would be before the new evidence code.
Right, in
Perfect.
Georgia, but it's 11th Circuit, so we adopted their evidence code. That's what we did. So this would be the law that from the 11th Circuit.
All right. So what section are you asking or inviting my attention to?
C and then 1. It's maybe halfway down in the opinion.
Okay,
C and
see,
then 1.
like
Yeah, so it
they
starts with
all
C and it's titled,
pre-planned.
"The District Court did
will
not
start between
abuse its discretion in
9:30
admitting
and
evidence."
10 a.m.
There's a paragraph explaining it and then goes into 1.
Nobody's surprised. Now, what are we actually waiting for? Well, first of all, there's a very, very funny segment on Wednesday when one of the lawyers, I keep forgetting his name, he's the junior, who sits in the far left, where we can see on your where you can see it's in that direction, where he called out Miss Love for being a liar. And oh, they started. Here's the thing. I don't want to miss anything of the cross-examination, so I'm going to switch over.
All right, Mr. Huey and Mr. Matthews Senior, good morning. One of the state's council sent you a,
I'm sorry, not.
sent you a location of two of the police reports, but one they haven't been able, but one of them haven't been able to find.
I'm sorry, Your Honor, I wasn't clear. That is correct, and they were helpful in that regard. I'm referring to the investigative reports that I inquired about last week,
Okay,
separate reports.
So, Your Honor, I'm not certain, and wouldn't ask for Mr. Sharp's plan attack here, but as it relates to him asking about, as he did at the bench, a particular interview of a particular person, I would ask that he be precluded from inquiring into the recordings of those and trying to get into getting the state to become a witness as to whether or not they were ever given it, because we have multiple documents bearing Sergeant Gaither's initials and the date that she copied it, along with the interviews that we have that were of her and another officer. So to the extent that our discovery in this case has been
Shit. Non-existent.
chock full of things that she did, if the implication is to be made that she didn't have them on the roster or something like that, we would ask that
This
is
is-
not furthering any aspect of the truth, if there is something specific.
This is Miss Love trying to say we don't need all those things that can say that Gautier is telling the truth. We have bits and pieces. That's enough, Your Honor. Jesus Christ.
That Mr. Sharp wants to talk about. Of course, we'll level an objection when it's mirrored again, but we would ask that he not be allowed to simply root at where is your report to a person who has not been at the Atlanta Police Department for 4 years or more.
Oh, fuck
And,
no.
to not be allowed.
Here's the thing. You called her as an investigator. You called her as an expert on gang witness, on gangs. You called her. It's your responsibility to have all the papers in order. If you don't, ta freaking da.
Out under 403 to not be allowed to mislead the jury about material matters in this case. If he has a specific one, that's different. If he has a specific objection, that's different.
Your Honor, that was fairly non-responsive. I asked specifically about, investigator testified last week that she wrote reports. I just noted that we hadn't had reports. On Wednesday, before we left, I just asked for those reports again, with the understanding that they may not be provided to me. And all I'm asking is, I guess the answer is no, the state doesn't have any additional reports. And
okay,
that's fine.
let's be clear about what they don't have, okay? And I'm gonna include your email from Sunday, the 28th at 12:51 p.m.
Right, that's a different issue, Your Honor.
They have the written reports under the two APD case numbers. The memo on APD letterhead authored by Detective Dennis.
Yeah, rule of
The
completeness.
surveillance video from the Vault Studio, those I don't think have been provided.
Right, and Your Honor, that's a separate matter. I was just thinking ahead to Investigator Dennis. We're not even there yet.
Okay,
I'm going back. On Wednesday, I inquired about reports that investigator stated she had written. And the state and Investigator Gaither stated they didn't have the reports on Wednesday. And that's fine. I accept that. All I'm asking is, has there been any change since Wednesday? And I think Ms. Love, by not answering it, answered it. No, there's no change since Wednesday. We still don't have the reports. And that's fine. That's all I wanted to know.
okay.
Yeah, and why shouldn't they be able to ask about it? Because it's the state's damn responsibility to hand over, because they used her as a witness. And the judge clearly states, if you're going to use a witness, all the evidence should be sent over that applies to that witness. And apparently, here goes the prosecution again, doing bad word all. And the judge probably will do absolutely nothing.
If Mr. Sharp could please elucidate exactly which reports that he is referring to so that we don't get here and have a slugfest unnecessarily and waste more time. The court would just inquire. which
It's a waste of
specific
time
reports
because
he's
you
inquiring about.
are hiding things
So
from
that we
the
can-
defense, Miss Love. You
If there's better
soulless.
answers provided, but just which specific reports, because we do have documents in here and reports from Sergeant Gaither. Just, I need to know the specific reports.
No, you don't. Just hand them over. She testified about certain cases. Those are the reports you should have handed over before. Judge, for Christ's sake, grow a spine. If they really can't supply reports, then you need to instruct the jury that they have to disregard everything, including, everything from those 4 days. And as a bonus,
Mr. Sharp, which
throw
reports
Miss
are you
Love
talking about
in the
terms of-
slammer for
Your Honor,
wasting everybody's time.
last week, Investigator Gaither stated that she interviewed certain witnesses to the Dexter Montgomery situation, the other individuals in the car. And I asked if there were any reports written. I asked her not on stand because I haven't crossed her yet. I inquired about reports. She said, of course I wrote reports. So then I said to the state, she's saying she wrote reports. And then we went through the big, we had a discussion about this. And they said, well, it should be in the case file. The state said they've done everything they can to get the reports, but they don't have. I've accepted, I'm not trying to open. All I'm saying.
Asking whether or not there's a change in circumstances.
Right, I'm just asking over the 4 days, has there been any change? That's all I'm asking.
All right, any change, Ms. Love?
Not from the ones that we provided already. So if there's an implication that her report is gone, damaged, missing, we would just point to the reports we have already with her name, signature.
Oh, great, Josh
copy.
Neville has a cold.
Some of them contain her warrant, some of them contain narratives from her. So the report itself, in one big file, is not a part of discovery, but her reports are interspersed throughout. So to the extent that there is a suggestion that will be made in front of the jury that something has happened, if she has an explanation, I don't care about
Well,
that.
I'm
asking them to not.
If you don't have it, then they don't exist. If you haven't supplied them to the defense, they do not exist.
Well, I think that Mr. Sharp's well within his right to examine about reports or what she did on this case. So I'll have to take it as it comes in terms of examination. Okay.
Yes, Your
All right. Anything else?
No, Your Honor, thank you.
All right. Mr. Steele, we're in receipt of your emails in regards to your exhibits. Ms. Weaver, as well as the court, have received those, so we'll include those as the next court's exhibits as well. Okay.
Of course, thank you.
All right. All right. Okay. Unless there's anything else, I'm happy anybody else. Let's bring in Detective Gaither, please.
And here she comes, the world's least competent gang expert. Oh, here's something I found out through a comment. I will not speak to the truth of it, but according to that comment, what Gauthier did during those years where she claimed she didn't answer to 911 calls, instead she did inquiries amongst the locals. That is cop speak for harassing young people. Oh, do you have drugs? Doing terror stops? Stuff like that. I can't speak to the truth of it, but I wouldn't be surprised.
You. All right. Sorry, name of some of our jurors, please, sir.
Now, cross-examination, folks. Cross-examination. Finally.
All right, thank you, Sergeant Ingram. All right, ladies and gentlemen, of the jury, good morning. All right, you sound good. Okay, without further delay, we're going to continue with the examination of Detective Gaither. Madam, you're still on the oath, okay?
Yes, sir.
All right. Cross, Mr. Sharp.
Good morning, everyone. Good morning,
Good morning.
former investigator Gaither.
Yes, sir. Good
Good
morning.
morning.
Good morning.
All right. Okay. I represent Shannon Stillwell. My name is Max Sharp. I'm going to ask you a few questions here. If you don't understand the question I ask, please ask for clarification, okay?
Sure will.
All right, great. First of all, I just wanted to follow up with your background. You said your law enforcement experience
Oh,
is
he's smiling.
solely with
This is so
APD,
true.
correct?
My longest tenure is with APD,
Okay, and how long were you with APD?
almost 19 years.
19 years, all right? And when you left law enforcement or left the police force, you were an investigator, correct?
No,
Okay, what were you?
I was a sergeant.
A sergeant,
You mean
okay.
with Atlanta?
Yes,
Yes, I was a sergeant.
okay, sergeant. As a sergeant, were you no longer working as an investigator, or is that is completely separate job duties?
I'm not understanding what your question is.
As a sergeant, would you still investigate crimes?
I would assist my investigators. I was in
Okay.
charge of investigators, so
She
we
was
would assist
I
removed
understand now. So
from
you
the
were
responsibility
supervising
to investigate
investigators.
before she
my
quit.
last assignment. Yes.
Okay. As an investigator, how many years were you an investigator?
I believe I made detective in 2013. I made sergeant, the official rank, I believe in 2013, and I made sergeant in 2016. So 3 years.
3 years. And when I'm saying investigator, you said detective, is that essentially the same thing?
It's the same thing.
All right, cool. And in your time as an investigator or detective, is it fair to say that you investigated complex cases, complex investigations?
Really just my time within the gang unit. I mean, from the beginning, I was assigned with learning how to investigate cases. So roughly 2007, when I went to the gang unit until I was promoted to sergeant in 2016.
Okay, so even before
Promoted.
you were a detective or an investigator, but you had that label, you were involved in what you would deem complex investigations.
I mean, complex in any type of investigation. Really, I don't just narrow it down to just complex. I mean,
Okay. All right. As an investigator or even as part of an investigation, you want to determine who committed an alleged crime, correct?
okay.
Is that correct?
If I want to find out who committed the alleged crime,
Yeah, as an investigator.
that's part of an investigation.
Okay. How an alleged crime is committed, that's something you'd want to figure out, correct?
Sure.
And also why an alleged crime is committed, correct?
Motive is always good.
Okay, and that's
It's
something
always
you look
something you
for.
find out.
That's something you look for as
I
a,
would object and ask that the lawyer allow the witness to finish her answer clearly on the record before I interject.
All right, Ms. Sharp, let her finish first before you pose the next question, okay?
absolutely, sir.
No problem.
Did you get my answer?
If you could repeat the answer.
Yeah, motive is something you would like to find out, but you don't always get it or understand it.
And that's something, motive is something you look for as a gang investigator, correct?
Motive,
Yes.
it doesn't always appear, but it's something that you would like to understand or know why something happened.
Right. It doesn't always appear, but that's part of your investigation is at least try to figure that out.
For the most part, yes.
Okay. In searching for these answers, who, how, why, details are important, correct?
Yes.
I stated questions of form.
In your investigations, you seek out the details.
Is there a specific type of detail that you're
Well, we'll get
talking
into
about?
that. Are details important?
Yes.
Okay. when you're speaking to witnesses, you want to get as many details as possible, correct?
Yes.
When you're speaking to eyewitnesses, okay? Eyewitness, a person who's actually saying they saw something,
Mm-hmm.
you would want to know, or if they came with you and let me rephrase this. If someone comes to you with information in an interview, you would want to know if the person actually saw something or just heard something, whether it was a rumor, right?
Are you speaking formal or informal? Because I think
Either
every
one. Either one. Formal.
Objection, Mr. Davis.
I state the question.
Formal interview.
a
If
form,
someone gives you information, you would want to know if they saw it with their own two eyes, correct?
I mean, that's why you would ask them, but do you really know if they saw it with their own two eyes? Maybe I'm just not understanding what you're asking.
Well, you would ask to determine if someone saw something with their own two eyes or whether they heard it from someone else.
Correct.
Okay. And if someone's saying that they saw something with their own two eyes, you'd want to know where the event that they claim they saw occurred, correct?
Speculation. Objection.
I stated objections to form. You can rephrase.
If someone is an
Only the
eyewitness or claim to be an
prosecution is allowed
eyewitness,
to speculate.
you would want to consider where the alleged crime was committed, correct?
Objection paid in speculation.
I'm overrule the objection. You can answer it, madam.
If they were eyewitness, I would assume they were there at the incident location, which I would already be aware where that occurred.
You would assume that?
I mean,
I sustain that objection.
Would you want to know where the witness was when they claimed to have seen the event?
Objection.
No, I'll allow that.
if they are eyewitness, they would be on scene, correct?
Well,
On scene of the
find
incident?
that out?
Yeah, you asked me what I asked them about where they were, and if they're on scene as an eyewitness, they would be on scene of the incident, correct?
Right, but you'd want to know where they were standing to make sure they had a
Oh,
vantage point, correct?
Correct, in that aspect, yes, when you
All right,
say
thank
it that way, okay.
Thanks.
Is this my microphone or is that yours? I'm hearing feedback. Okay,
Tell me if you hear more feedback.
absolutely.
All right, because vantage point would help assess whether the witness could have actually seen what they say they've seen.
Sure.
Okay. We talked about details, let's talk about reports. 19 years with APD.
Almost. Mhm.
You were trained to write reports,
Yes.
okay, and police, and when I
Thank you,
say
Nana,
reports, I'm
Mr.
talking about police reports.
Yes, I understand what you're asking.
Okay, and there's initial reports and there's supplemental reports, correct?
Yes.
And investigators, you write many supplemental reports, follow-up additions to your investigation, correct?
Or case notes, not necessarily supplemental reports, but we would call them case notes.
And are case notes also typed into a system that generates a report, a written report?
They can be.
Okay. And in these reports or case notes,
Mhm.
you memorialize events or your investigation in a timely manner, correct?
Can you ask that one more time? I'm sorry.
You know that at some point down the line, you may be asked to testify
Correct.
about events, correct?
Correct.
And one of the purposes of reports is so you have the facts and details down when they're fresh in your mind so you can refer back later on. correct?
Yes.
Okay. And in these reports, you want to put as many details as possible, correct?
Yes.
And you want details and you also want accuracy, correct?
Yes.
And you've been trained to write reports,
Yes.
all right? And you do write reports as part of your job, or you did when you were with APD.
I did.
And that's expected of you as an APD officer, correct?
To write a report regarding a specific
Write
incident, or
reports
are we talking
generally.
about investigations?
To write reports to accurately memorialize your investigations.
Yes.
Okay. All right. I want to speak to you a little bit about the Dexter Montgomery case, okay?
Mhm.
From 2015. And first, just to help keep things clear, you would agree that there's three cars involved in this case?
Yes.
All right. I'm going to refer to the blue car, and that would be the car that Dexter Montgomery was in, correct?
The victim's vehicle?
Okay. Is it
The
blue
victim's
car?
vehicle.
What would you like to refer to that vehicle as?
The victim's vehicle.
Okay, well, I'm going to use a descriptive color. So
Okay.
what color car is that? Okay.
Yeah, no, that's fine.
All right.
I was making sure we're talking about the same vehicle, the victim's vehicle that you're speaking about,
Okay.
blue one.
Silver Pontiac.
Okay.
That was the car that Ms. Clark, Mr. Treadwell, who's OG Bentley,
Mhm.
Mr. Allison, and 2 children were in, correct?
Yes, sir.
All right. And the white Nitro is the car that shows up with Mr. McMullen and Mr. Murphy, correct?
Yes.
So this incident occurred on April 12th, 2015. You would agree, correct?
Yes, sir.
All right. And it was reported to police on April 12th, 2015, correct?
Yes, sir.
All right. When, and you are, do you consider you're the lead investigator on this case?
Not initially, no, I was not.
Okay, but eventually you were the lead investigator?
Yes.
Okay. What date did you become the lead investigator on this case?
I'm not sure of the exact date. I don't have my case file, but it was several weeks after the initial incident report.
Several
I'm
weeks
sure.
after? Okay. Do you have a report that can tell us exactly what day you became the lead investigator in this case?
I do not have my original case file.
Okay, did I ask you on Wednesday to bring it?
object to hearsay statements made outside the court. I would ask if there are documents.
I'll rule the objection. You can finish.
Thank you. Did I ask you to bring your reports to the court today?
You asked me, did I have them? And I told you, I do not have anything from Atlanta Police Department.
Okay. So you do not have your reports?
I've already answered that, sir.
Okay. And you cannot tell us the date that you became lead investigator on this case?
The exact date? No, it was at least it was less than a month, but it was roughly 3 to 4 weeks from the time the incident occurred.
Okay. Now, last week, do you remember being asked about different witnesses and about if any of these witnesses said they saw a gun being pulled by anyone in the blue car at the gas station?
Specifically, are you speaking about anyone in particular? Mr.
Anyone in the blue car? You did not see. We've seen the video,
Correct.
all right? And let's just be upfront.
Mhm.
In the video in the gas station, we don't see anyone in the blue car pulling a gun, do we?
No.
Okay. And you remember last week when you were asked, speaking to different witnesses, if anyone claimed that anyone pulled a gun out of the blue car or pulled a gun, anyone in the blue car pulled a gun. Do you remember being asked that?
I don't recall specifically in that, the way you're saying it now, I don't recall that.
Okay. Do you remember being asked if you spoke to Cornelius Davis?
Yes,
And you indicated that you did interview Cornelius Davis.
yes.
She can't remember what she testified to last week because the question is asked the wrong way. To me, that indicates it was rehearsed. people who either bolster or lies, they have to be asked questions in a certain order to remember it. As soon as you question them out of turn, boom, gone.
Okay. What date did you speak to Cornelius Davis?
Again, I do not have my original police report. I do not have that file with me. I don't have it at all, not even just with me. I don't have it.
Okay, and would that be one of the police reports that I asked you to bring to court?
Would it be? I don't have that case file again.
Yeah.
Where did you speak to Cornelius Davis?
He was picked up from his residence.
Okay. Terrion Moody, when did you speak to Terrion Moody?
Again, the exact date, I'm not sure. All of the victims were spoken to. It had been roughly a month, again, since the incident occurred. So it was our priority to try to get their statements as soon as we could, myself and investigator Dennis. So from the time the case was assigned to myself, which was again roughly 3 to 4 weeks after the incident occurred, within a week's time, everyone outside of Dexter Montgomery who was in the hospital we spoke to.
Do you have a report that with you that indicates when and where you spoke to Terrion Moody?
I've already answered that.
What was your answer?
I do not have that case file, sir.
What about Christian James? What date did you speak to Christian James?
It's my same answer as the previous question.
Which is what?
I just answered that, sir.
Well, I'm going to ask you to answer my question.
And I just answered, my answer is the exact same answer as the previous answer question.
She still needs to
Okay,
answer
and I'm
it.
going to ask again because this is,
Move on, Mr. Short.
What? Oh, why?
is your answer that I haven't gotten an answer.
You haven't posed your question. All right, sir, go ahead.
So, you don't know what date you spoke to Christian James either?
Objection, ask and answer.
She hasn't answered.
You haven't answered that. I'll rule the objection.
I do not have my case file from this particular incident. I did not have it from the time I retired.
Imagine an expert
APD.
witness.
I do
The
not have
prosecution
in my
doesn't even
possession
bring her
any
case files.
files from any case that I've worked.
Okay, and when I asked you to bring your reports last week, I asked you to bring your reports Monday. And you indicated that you're no longer with APD and you might have trouble getting them, correct? You said you wouldn't be able to bring them, right?
I said I wouldn't be able to bring them because they're not in my possession. I do not have anything from Atlanta Police Department.
But when I asked you for those police reports, District Attorney Seth Brown was there as well, correct?
Yes, sir.
From the District Attorney's office, he was aware that I was asking you for those police reports, correct?
Your Honor, I'm going to object as to this witness testifying about what someone else was aware of.
I sustain the objection.
Was he actively involved in the investigation? Was he actively involved in the conversation between me and you in that back room?
Objection as to relevance of whether or not, and
I sustain the objection.
If this was the prosecution, he
Been
would have
doing this for
allowed
a
it.
while,
Doing what?
investigating crimes?
I'm no longer investigating crimes, sir.
Okay. Been to court before to testify?
Yes,
Testified in trials?
I have.
Okay. You're aware that police reports, if they exist, are to be provided to the defense in discovery, correct?
If I have a police report, I'll give it to the district attorney's office, and I would assume they would transfer it over to you.
Okay. And you don't have these police reports indicating the work that you say you did
Your Honor, objection.
from
as to
2015?
I'll sustain the objection.
Okay. Where's your case file?
I don't have it, sir.
Well,
I
where
left-
is it?
I left. When I retired from the Atlanta Police Department, I believe it was August 2020, I left everything regarding Atlanta Police Department at the Atlanta Police Department on the 5th floor where our officers work. That included all of my case files, all of my uniforms, all of my equipment. I do not own anything but my Atlanta police badges I accumulated over the years. That is all I own.
Who did you leave them with?
Sir, I just answered that question, sir.
You said you left them on the 5th floor. Whom did you leave them with?
I left them in our offices on the 5th floor in a file cabinet. We are not allowed to take our case files with us once you retire. I have no purpose for them.
Yeah, the point here is that the prosecution, knowing she has been retired for 4 years, and judge allowed her on as an expert witness and a fact witness without any reports. So naturally, the defense should be able to ask, where are those reports? And since the prosecution refuses to hand them over, or can't find them, or they've been destroyed, or whatever's, this should go to her credibility as a witness, not through her own fault, because the prosecution more or less forced her on the stand. So everything here, the dialogue here now is between the defense and the prosecutor through this witness. That is what they are trying to converse to the jury, that the prosecution is shady, they are hiding stuff, they are not turning things over. So this is more or less what this is about.
As part of your work on the Dexter Montgomery case, you showed you showed photo lineups to witness D'Angelo White, correct?
You said to D'Angelo White?
Yes.
Yes, sir.
Did you know what date that occurred?
Specifically, no. It should be with the case file. As you can hear in the audio, that actually happened, so.
Okay. Right. We have audio of that. Where is the audio of the Terrion Moody interview?
I've already answered that, sir.
Where is the audio of the Christian James interview?
This is my same answer as previous.
Where is the audio of the Cornelius Davis interview?
I think you've already asked me that. For all of these audio interviews that you're requesting outside of D'Angelo White and the ones that have been provided to the court, I do not have access to them at this time.
You were in the car when Mr. White looked at the photo lineups, correct?
I was.
Okay, you were in the car with Investigator Dennis, correct?
During the interview?
Yes.
Yes, Investigator Dennis and Investigator Edwards.
Investigator Edwards, okay. Who administered the photo lineup?
Investigator Dennis had the actual file. I was driving.
Okay. Who wrote on the lineup?
Wrote what?
May I approach?
You may, sir.
If the case file doesn't
Have you
exist,
shown that
where
to the
did the
state?
prosecution find all the photos and all the pictures and everything? I say it exists, but the prosecution know it looks bad because incompetence. I'm saying it out loud. I think the prosecution, either the prosecution themselves destroyed
As
it,
part of the photo lineup,
or
little statements
police
about
did it.
what, and we're going to talk about the statements.
You
but
said little statements?
statements
Okay.
about what D'Angelo White said
Yes, sir.
are handwritten on the lineup, correct?
Yes, sir.
Okay. Were those written by you? Is that your handwriting?
Yes, last week we went over this, that this was my handwriting. This is also my handwriting.
Okay, great. You can't hear the witness.
I'm sorry, sir. Can you hear me?
Yes. Okay. And now there was 2 lineups shown to D'Angelo White, correct?
Yes, sir.
Okay, one, and in the lineup, just to be clear, there's a target or an alleged suspect, right?
In each lineup?
Yes.
Yes.
And then there's 5, usually in this case, it's a 6 photo lineup, so there's 5 fillers.
Correct.
And one of the targets on one of the lineups was Kelvin Treadwell, who's also known as OG Ben, correct?
I didn't label them as targets. They were, for me, persons suspected as being involved in the crime, but target is your word.
Okay, I'll use suspect, that's fine.
Okay.
So one of the suspects was Kelvin Treadwell.
Yes, sir.
And in the other lineup, the suspect was Walter Murphy, correct?
Yes.
Now, let's first talk about the Walter Murphy lineup, which was lineup number 2. You wrote on 7/13/15 that D'Angelo White identified Walter Murphy, AKA DK, as person with assault rifle and shooter, correct?
Yes.
Okay. When you say person with an assault rifle and shooter,
Yes.
are you saying he was identified as the shooter?
According to Mr. D'Angelo White, yes.
He was identified as the shooter.
He was identified as a person with the rifle, and he stated he believed the passenger was the shooter because it would be hard for the driver to drive and shoot a rifle.
Well, actually, in his interview in that car, he indicated that the shooter was definitely on the driver's side, didn't he?
He did. And he also stated that it would be hard for the driver to drive and shoot. So he believed it was the passenger.
Well, actually, he in his statement to you in the car, he indicated that his thought was the shot came from the backseat driver's side, correct?
He said the passenger shot.
Okay, Your Honor, I'm going to ask.
That's still a
Publish-
passenger.
I didn't say the passenger side. I said he stated the passenger shot.
Passenger being who? In the back seat or front seat?
I don't believe he identified, but we know that Walter Murphy was a front seat passenger with an assault rifle.
Oh, by the way, this witness was asked by the prosecution if she could identify a shell casing laid on the ground, if that was similar to what she knows by experience is being shot from certain assault rifles. And the shell casing had a dent in it. It could have been there for days, weeks. And this specific witness has already admitted on the stand that she spent the first 3 or 4 years actively avoiding doing work.
Okay, we'll come back to that. So your statement is that he said because the driver couldn't have been the shooter. But he's assuming because he was driving, right? Is that what D'Angelo White said?
Your Honor, I'm going to object to line of questioning involving speculation.
I stand the objection.
Well, what did D'Angelo White say about who shot?
Sir, I just answered that.
Well, could you answer?
Sir, I just answered that.
I stand the question.
He said it wasn't the driver.
Objection, asking the answer.
I stand the question, sir.
Did D'Angelo White ever say, I saw DK, or I saw Walter Murphy, or I saw the person in this photo shoot at the car I was in?
Sir, I just answered what D'Angelo White stated his remembrance of events were regarding the shooting.
Did he ever say, I saw this man shoot?
Your Honor, I'm going to object, asking this.
I stand the objection.
The truth is, he said he couldn't see who shot, isn't it?
Is that your truth or his truth?
I'm asking you. It's on tape.
Sir, I've asked.
Then I would ask that the best evidence be shown to the jury since Mr. So I object.
Your Honor, I'm just asking that the witness answer the question.
I'm gonna overrule the objection.
Did D'Angelo White ever say he could see who shot?
D'Angelo White stated he did not believe the driver could be able to shoot a rifle and drive. So he thought the passenger, who was Walter Murphy with an assault rifle, shot the
So
assault rifle at his
thought
friend. He
is not
also
good
stated
enough.
the backseat passenger, who was what he said to be a young man named Fatty, he had a handgun. The victim was shot with the assault rifle round.
So he never identified Walter Murphy as the shooter, did he?
Objection, Councilman.
I sustain the objection.
Did he ever say that guy was the person who shot?
Mr. Short, it's the same question. Let's move on, okay? Thank you, sir.
This is ridiculous. He allowed Miss Love doing
But
all of this
You
in
wrote
direct
that he
examination.
identified him as the shooter, correct?
I've already answered that, sir.
All right. Let's talk about the identification of Mr. Treadwell or OG Bentley. You also wrote on that photo lineup too, correct?
Yes, sir.
And you said he identified Kelvin Treadwell, AKA OG Bentley, as ordering the shooting.
What's your question, sir?
Is that correct?
That's what that reads?
May I approach?
You may, sir. Just show what exhibit you
Is that
show.
what you wrote?
I think you-
13 BBA, 73 BBA. Is that what you wrote?
Yes, that's what I wrote.
Okay. Identified Kelvin Treadwell, aka OG Bentley, as ordering the shooting. Did he say he saw Kelvin Treadwell, OG Bentley, order the shooting?
He stated that OG Bentley was on the phone making a call, and what he believed was calling Walter Murphy and Demise McMillan. He didn't say those persons' names.
Did he say he saw that with his own eyes? OG Bentley on the phone? He heard that?
I'm telling you what he told me, that he believed OG Bentley, the person he didn't know is Kelvin Treadwell, but it's OG Bentley, made the call.
He believed.
I can't tell you him what not to believe. That was his thoughts. That's what he
I
stated.
asked him what he said he saw or heard. The truth is, you've seen the surveillance. D'Angelo White never got out of the blue car in the parking lot of the Citgo, correct?
That has nothing to do with what he saw.
Okay, so you're saying that D'Angelo White was sitting in the blue car in the Citgo that night and heard and saw OG Bentley, also known as Kelvin Treadwell, making a phone call from inside the store.
Objection.
That's what you're saying?
Objection, badgering number one. Objection, cause for speculation. Objection, as
I sustain against all three bases.
Bullshit.
Is that what
Your
you're
Honor.
saying?
Objection.
You coward.
Sir, I've already ruled, so formulate another question. Okay, thank you, sir.
This is so ridiculous. He allowed Miss Love to do all of this. And in cross-examination, you should have more leeway, not less. Spineless judge. The prosecution was allowed to speculate, but because the mix-up between expert witness and fact witness.
Your Honor, we're just gonna publish.
Yes, sir. Make sure you tell us what exhibit you're publishing.
Now, in some way, the judge is actually making correct decisions. Somewhat. You could disagree or agree, but he's making somewhat correct decisions. That's not the issue here. The issue is his bias towards the prosecution, when he allows the prosecution to do this and he doesn't allow it when during cross-examination, where they should have more leeway. Seems like I can skip ahead a bit.
Publish 102 BB. 102. 101 BB? Okay, 101. All right, at 13:55. All right. Yep.
Answer this. Did you see where the shots from the other vehicle came from? Like, did the person, which side of the car did they lean out to shoot?
It had to be either on it couldn't be from the goddamn, it couldn't be from the passenger side or from the back passenger side. It had to be either, it couldn't be the driver neither. It had to be the person behind the driver.
Thank you. From your investigation, Walter Murphy was sitting in the passenger side, correct?
Best of my recollection, yes.
Okay, and you just heard D'Angelo White. That was D'Angelo White's statement, correct?
Yes.
And he said it couldn't be the passenger side. It could not be the passenger side, correct?
I did not say it was the passenger side that the vehicle was shot. I said the passenger. He stated the shots came from the driver's side. I stated it could not have been the passenger side.
You
It
stated?
had to be the passenger, not the passenger side of the vehicle, is what I stated.
Mr. Murphy was seated in the passenger front, according to your investigation, correct?
And also according to Mr. Murphy, yes.
And Mr. White just said on tape, it couldn't have come from the passenger side, correct?
If you go to his interview inside our vehicle, he also stated he did not believe it was the driver. It came from the driver's side, but he did not
Yeah,
believe that it was
fact.
the actual driver. It
Okay.
was someone from
And it
the
was-
passenger. Sir, are you gonna let me answer?
Yes.
Okay, he stated he did not believe it was the driver because he didn't think the driver could drive and
But
shoot
you have the
gun.
driver's
He
side
stated that
passenger.
it had to have been the passenger. I didn't say
Jesus
the
Christ.
passenger side of the vehicle. I said the passenger.
But Murphy sat on the
There's a
passenger
third
side.
person in the car, in the back seat, correct?
Correct,
And
which
that was not Walter Murphy, was it?
I don't know, I don't believe so.
Okay, and somehow that statement has become you writing down that he identified Walter Murphy as the shooter.
And somehow you're trying to get away from the fact that YSL, members of YSL shot this boy in the head. Whether it's a report,
Okay.
Yeah.
let me step out, sir.
That was so improper. Now, not only she's not allowed to do that. She is not allowed to do that. This is clear mistrial territory. Clear mistrial territory. And dun dun dun. Sidebar counter 154. Yeah, this is extraordinary bad. The witness is nowhere near allowed to behave this way. This is not only mistrial territory, it's contempt of court territory. And this judge has clearly, throughout pre-trial, thrown this contempt of court right and left. Yeah. Exactly, Patty B. How are you going to say that? She don't have a good answer, so she throws the sympathy card. And after 19 years on the force, she knows she's not allowed to do that. But we also know she is completely incompetent. Yeah. She needs to be reprimanded and told off by the judge, you only answer the question as they are asked. Asked, not axed. That mistrial, contempt of court. Jesus Christ. Beautiful decision. So I'm watching different channels. Sorry. No worries. No worries. Thank you for being here. They had this weird doco on the judge that said he ruled a mistrial on a trial that later got deemed the wrong call. Yep. This judge has been a judge since 2005. And apparently, Mr. Steele brought Judge Glanville in front of the Bar Association at one point. And so did I timestamp? Can I? Where do I timestamp? I am 1:02 into the stream, so around the 1 hour mark in my stream. And in the Law and Seaward stream, it is roughly 1 hour and 20 minutes in. Jesus Christ. Here's the thing. The judge cannot let this go, and he knows it. But he's also a coward, and he has no spine, and Miss Love is a soulless being. So, yeah, and some of the objections are in the territory of being sustained, but not in this trial if you compare it to what he allowed the prosecution to do. And he talked Wednesday about having a fair trial for both the prosecution and the defense. And I say to that, fuck no. There's, according to the Constitution and the Bill of Rights, there's only one who has rights, and that is the defendant. That is why the prosecution has all of the burden of proof. And doing this, hell no. See here, I can skip ahead a few seconds at least, but I would assume they are going to be up there a good while. What I want the judge to do now is to send the jury home. After he said to them, you must completely disregard that final comment from the witness. And then he should have a contempt of court hearing. Dark Horse Production, welcome again to the US court system. It has fallen off. If you haven't seen, because it's not only the court, it's foul play from the prosecution. Because prosecution is extremely powerful. They can ruin. I mean, I'm going to say you can have terrorist acts. They are not a threat to either a constitutional republic or a democracy. We should be stronger than that. What we don't have a defense against is corrupt prosecutions, weak judges, and a government who allows it. Oh yeah, the word I'm saying fork, not the bad word. You know, fork and spoon. Spork. They are going to be there for a while now. Yes, I like forks. Oh, and before I forget about it, where did it go? Didn't I store it? Oh, they're going back. Thank you to Nana Misty, who an hour ago or 40 minutes ago gave me a super chat. Thank you so much. Good morning, Nick Ghost in chat. Hope everybody had a good weekend. I had an excellent weekend. Thank you so much. And thank you for your support of the channel. Say it, Judge. Say it. Say it. Tell the jury. Get on with it, Judge.
So yeah, you may
In
continue.
this courtyard.
What?
Investigator Gaither, as we see.
How the fuck, Fork, does he not admonish the witness in front of the jury? Jesus Christ, you spineless piece of garbage.
Here in court today, that note that you wrote on 7/13/15 that D'Angelo White identified Walter Murphy as the shooter or the person who shot. As we sit here today, is that an accurate report of what was said?
I was saying to get a question, it's asked and answered.
What?
Move
What?
on, okay?
Well, I'm just
It's asked and
Are you
answered. Move on.
serious, Judge?
the report you wrote that D'Angelo White identified Kelvin Treadwell as ordering the shooting. Was that an accurate report?
Yeah, I'm going to object.
Basis. I don't think he answered that. I'll
No!
support the objection.
Coward.
Sir, that's what I wrote.
Let me ask you,
She didn't answer. He's just bolstering and
this document
filibustering
that I'm reading off of this
because she
this
knows
photo
she
lineup
lied.
Which is states.
states 73 BBA. Thank you, John. When you left the police department, what did you do with this?
What I do with what? You have it in your hand?
Yeah, what did you do with it when you left the police department?
Objection.
Did it go in the case file?
Objection made.
I stand in objection.
Did you, 73 BBA, the photo lineup that you wrote on, did that go in the case file when you left the Atlanta Police Department?
I believe you just asked me the exact same question.
No.
that you
I
did
didn't.
before.
I didn't.
Okay.
Could you please answer my question?
What's your question again, sir?
73 BBA,
Mm-hmm.
photo lineups, when you left the police department,
Mm-hmm.
did these photo lineups end up on the 5th floor?
Objection, Your Honor, that would call for speculation.
I stand in
What did
objection.
you do with the photo lineups when you left the Atlanta Police Department?
Objection, Your Honor, she answered that.
She has not answered that.
She's answered that already.
No!
She's asked and answered.
You
Move on.
coward.
She answered
She's
about-
asked and answered that question, sir. Please move on.
Did you do anything different with these police reports than you did with the other police reports that we can't find?
Objection, Your Honor, injecting facts that are not in evidence about the weekend.
I stand in objection.
You absolute.
We have this one though. But you don't have the other police,
You fucktwat.
right?
Objection made.
I'm saying
Stand in
four quad.
objection.
I'm saying four quad.
Hey, I want to talk to you a little bit more about the conversation you had with D'Angelo White in that car. D'Angelo White wanted $20 for helping you out or helping the police give information, correct?
He did.
Okay, and you, obviously you didn't pay him to give information, correct?
Not paying anyone to give information, not just him. That is not how I work and how I did police work.
Fair enough.
Overrule objection by Mr. Steele.
Fair enough. But you did speak to him, even though you didn't pay him, you did get him to speak about what had happened, correct?
By his account of what occurred, yes, sir. Yes, sir.
Okay. He indicated that he had a familiarity. He knew who O.G. Bentley was, correct?
Correct.
And he
He knew
referred
of
to.
him. I'm sorry.
I'm sorry.
He knew of him.
Okay. And just for the record, when I'm saying O.G. Bentley, we're talking about government name Kelvin Trent.
Yes.
Okay, and that's the rather large, light-skinned gentleman on the video.
That's your description of him. I mean,
Okay, he
I've seen larger.
gentleman that got out of the silver Pontiac.
The light skin with the white t-shirt, short sleeve white t-shirt. Yes, sir.
All right, and ended up going into the store.
Correct.
Now, D'Angelo White said that O.G. Bentley was known to carry large amounts of money, correct?
He did say that, yes.
And D'Angelo White, in his mind, associated O.G. Bentley with someone who worked for the rapper Young Thug.
Objection, speculation is putting someone's mind.
I stand.
It's
I
in his
stand
statement.
there.
Your
In
investigation.
his statement, he associated O.G. Bentley with Young Thug.
Yes.
Per Walter Murphy, in his interview with you, he also said that at one point, O.G. Bentley actually worked as a road manager for Young Thug, correct?
I believe he said something to that effect. I'm not sure of his exact words, but he did. He stated he worked for him in some capacity.
But Young Thug Jeffrey Williams had since cut ties because O.G. Bentley was stealing from him, correct?
According to Walter Murphy.
Okay, so according to Walter Murphy, at the time of this incident, there were no ties between O.G. Bentley and Jeffrey Williams on a professional level.
Objection, Your Honor, statement. Objection.
I'll stand in objection as a form. You can rephrase, sir.
Either way, D'Angelo White associated O.G. Bentley with someone who would have money in his state, correct?
What do you mean by either way in regards to the follow-up?
I stand the objection.
In his statement, D'Angelo White associated O.G. Bentley with someone who carries around large amounts of money. In his statement to you.
That's what he stated, yes.
Okay. And he also, D'Angelo White, acknowledged that his cousin, or excuse me, Dexter Montgomery's cousin, Cornelius Davis, was driving the car, following O.G. Bentley's car closely.
Objection.
I stand as a form. You can rephrase.
He acknowledged that the car they were in was following the silver Pontiac closely.
Those weren't his words. That was Investigator Dennis's words.
Did he affirm?
He stated, Cornelius, he a young and, he drive the way he drive. And as he was stating that to us, he was, stating he drives wildly, not he was following too closely.
D'Angelo White told you and Investigator Dennis that O.G. Bentley must have thought we were going to rob him, correct?
Yes.
Did you, as the investigator, bring up robbing O.G. Bentley?
I did not.
Did Investigator Dennis bring up robbing O.G. Bentley?
I don't believe he did.
Okay, it was D'Angelo White in the interview who first said anything about O.G. Bentley must have thought we were going to rob him, right? He wasn't prompted by any of you police officers to say that, right?
Compound objection.
I stand as a form. You can rephrase, sir.
Did he bring it up on his own?
He did.
Walter Murphy, in his statement, indicated that OG Bentley thought the guys in the car were going to rob him.
Objection. Made.
Correct?
Objection made before the statement.
I stand the objection.
Walter Murphy, in his statement on August 18, 2015, indicated to you that OG Bentley thought the guys in the blue car were going to rob him, correct?
I'm not sure which exact statement he made that comment, but
Really? You testified to it last week.
are you asking me?
Yes,
Did he make the comment that he thought they were going to be robbed?
yes.
I believe he did. I'm not sure which
Okay.
statement though.
So the idea of robbery not brought up by the police, and no one suggested that to Walter Murphy either from the police department, correct?
I can't answer your question with a yes or no or correct or incorrect. I can give you an explanation for what my opinion was of Walter Murphy.
I'm not asking your opinion.
Well, I can give you the facts of what I understood Walter Murphy's statement to be, so I can't
Here's how it's
answer.
gonna work.
I'm still answering.
I'm gonna ask a question.
Basis.
That the lawyer allowed the witness to answer.
Yeah, let her finish. Okay.
What?
Did you suggest Walter Murphy?
I wasn't done answering.
Your Honor, it's non-responsive.
Why don't you just rephrase the question, sir?
Did you personally suggest to Walter Murphy that there was a robbery afoot?
I didn't suggest that to him, no. He was giving me his account of what he believed happened, and the majority of his statement was based on once he received discovery and hearing other people make statements, he was working his story to work with their story. So if we didn't know a particular person or a particular statement was made, his way of trying to get around telling us information was kind of telling us stuff we already knew.
Now that you got that out.
That was my answer.
Okay.
I stand the
So
objection.
D'Angelo White,
Let's drop the commentary, okay?
D'Angelo White, when he made his statement about OG Bentley must have thought I was gonna be robbed, did he see the discovery too?
Did who see the discovery?
D'Angelo White.
Discovery wasn't a thing yet. It
Okay.
hadn't gone to court.
So that would be no, he hadn't seen the discovery.
No, he had not. There was no
Well, he
discovery
brought
to
that up
see.
too.
I'm sorry.
You gotta let her finish, sir. Okay?
There was no discovery to see. We weren't at that stage of the case yet.
But D'Angelo White brought up, but OG Bentley must have thought he was being robbed too.
Yeah, objection, ask and answer. No.
I stand the question.
Do you have any evidence that Walter Murphy and D'Angelo White, those two individuals, ever talked together and said that this must have been a robbery?
I've never said that they knew each other or spoke with each other to come up with that particular statement.
But they both said it.
D'Angelo White's statement was first, and Walter Murphy's statement was after, which means he would have had part of our evidence from his case file when he was arrested from his lawyer.
That's objectionable.
In the interview in the car with D'Angelo White,
Yes, sir.
Investigator Dennis asked Mr. White if anyone pulled out a gun on people in the Silver Pontiac, correct?
I believe he did.
Okay. And D'Angelo White's response was, we had guns and shit, correct?
Yes, he did say that, and it was more to that as well.
We had guns and shit.
Yes, he stated that.
Okay. We being plural, correct? Correct?
Are you insulting my intelligence by asking if we mean plural? I think you are, though.
Okay.
I think you are.
All right, well, answer my
Sir,
question.
don't do that. Don't do that.
This witness should be thrown ass first in a jail cell.
All right, sir, let's be respectful to our witness,
I'm being
okay?
very respectful, Judge, and I always will.
I doubt it.
Guns being plural.
I'm going to object to the last response by the witness as commentary.
I'll sustain the objection. All right, Mr. Sharp, please, this is focused on the questions.
I'm trying to.
No, just focus on the questions.
Jesus
And
Christ.
Detective, please just answer the question.
Here's the thing. Plural. It's not insulting her intelligence by asking if guns are plural. Now, if she doesn't know what plural is, then she's a fucking moron. Yeah, I wouldn't. I'm so happy I'm not in this trial.
My apologies to the court,
It's all
sir.
right, sir. All right.
Guns being plural as well, correct?
He stated that's what he said.
Objection, ask.
I sustain the objection.
I haven't asked.
Here's the thing. The judge won't do anything. You heard him. He started
Remember
demolishing the
last
defense
week
instead. When he should be
When you were
throwing the
testifying,
law
we
on
talked
this
about-
witness.
Or Ms. Love was asking you questions and you referred to people in the blue car as practically children.
No, I don't recall that being the exact thing I said.
Okay. Well, which we heard, we and guns. As an investigator, did anyone seek further clarification from D'Angelo White when he say we? Who in that blue car possessed guns? Did anyone ask?
Ask who had the guns?
Yes.
That's not on the recorded statement, sir.
So did anyone ask? I understand it's not in the recorded statement.
Mhm.
Did anyone ask who in the blue car had the guns?
I don't believe the jury heard that, so it's not on the statement.
So that's a no.
We did not ask him that.
Okay. Did anyone ask how many guns were in that blue car?
Sir, that's not on it, but that goes to part of we did not further inquire about the guns that he stated we had. So every question regarding the guns and who and we, and as we all know, we heard the recording. It's not on the recording, therefore we didn't ask him that.
Did anyone ask what types of guns were in the blue car?
Objection, ask.
I never asked that.
I will rule the objection. You can answer that.
Sir, no further inquiry was asked about the guns that they had that Mr. D'Angelo White said they had in the vehicle.
Okay, and as lead investigator in this case, and I understand that you weren't there on that night, you're aware that guns were not located in the car.
The night of the incident?
Right.
Yes, I am aware of that.
The car relocated itself to an address at 1987 Fremont Avenue, correct?
It did.
Okay, did anyone search the 1987 Fremont Avenue address for any guns that may have been discarded there before the police arrived?
Objection, assumes facts not in evidence.
Stated.
Speculation.
I sustain the objection.
He
Was
was just asking if
1987
anybody
Fremont
looked
Avenue
for
searched
it.
that night?
Jesus Christ.
Sir, as you just stated, I was not there on the night that the incident occurred.
So you don't know the answer to that question?
I personally did not execute a search warrant on Fremont Street.
Okay.
Thank you, John Comyon.
Now, you've been able to review, in court, in fact, we reviewed the surveillance from the sit-go from that night, correct?
Correct.
Would you agree that we can see the blue car pulling into the gas station, following behind the silver Pontiac?
Objection, as to characterization, best evidence is the video.
Okay.
I sustain.
Mr. Kokomo, could you please pull up, that's fine. DS9 at 1340.
Yeah, the judge is this is so cowardly done by the judge that in the midst of this, He's actually
Before we
defending
start
this
playing,
witness.
Did you ever ask D'Angelo White or any of these other individuals that you say you interviewed, why they went to the gas station?
I don't recall at this moment.
Okay. And this gas station, this Citgo, it's a place that sells gas, correct?
Among other things.
Okay, and it, well, among other things, it has a store where you can buy chips and
Like a food mart, yes, sir.
headache powder and different things like that, correct?
It's a food mart.
Okay. All right, Mr. Kokomo, if you could publish DS9 at 1340. Okay, Investigator Gaither, did we just see the two cars pull into the Citgo? The two cars, meaning the silver Pontiac and then the blue car?
Yes,
Okay, and the silver Pontiac is the one that O.G. Bentley and Rodney Allison are going to exit, correct?
yes,
And the blue car is the one with D'Angelo White, Terrion Moody, Christian James, Cornelius Davis, and Dexter Montgomery, correct?
the victim's correct.
Okay, you keep saying victims, and that's cool, but,
Objection, Your Honor, as to, commentary by Mr.
I stand the
and
objection.
that's the car that D'Angelo White said that there were guns, plural, in, correct?
Yes, in their vehicle, yes.
Okay. So 2135, they're there. Mr. Kokomo, if you could play.
Bless you.
Sadly, Brandon, that requires they are actually allowed to ask rough questions
Okay,
to
Mr.
this
Kokomo,
witness,
could you
and the judge doesn't
could
allow
you
it.
fast forward to 2200? Okay, and for the record, we're going from 2135, I believe it was, to 2205.
Sir, is there?
Excuse me, I'm sorry. 1340 to 2205.
Sir, is there any particular point you want me to
Well,
start
I'm gonna
watching,
try to
or am I
save-
looking for something in particular?
I'm gonna try to fast forward it. I'm
Okay.
gonna try to save some time, because I don't wanna watch the whole video again,
Okay,
but we'll see where this goes.
okay.
Your Honor, I would ask Mr. Sharp to just clarify, he has 4 separate videos on the screen for the record. So to clarify which, one of these images he would like the witness to focus on.
I'm gonna ask the witness to focus at 2205 on the top left. If you could get to 2200.
All right, let's know when you get there.
Okay, and I have 2144, the blue car is leaving, correct?
Yes,
All right, and so you would agree the blue car, and we can go back and watch if you want, but would you agree that the blue car was present for about 8 minutes?
I'm not sure the exact time of timeline.
All right, I guess we're gonna have to do it this way. 1340, please. Okay, please note on the top left, Investigator Gaither, it says 2135.
Mhm.
50.
Okay.
And for the record, both cars are present now, correct?
Yes.
Yeah, we are going to sit and watch because this witness don't know time. She has no clue how to subtract
And
1340
Investigator
from
Gaither, what I'm gonna ask
2205.
you to watch over the next 8 minutes or 9 minutes is whether anyone in the blue car
Mm-hmm.
either pumps gas or goes into the store to buy any items.
Objection, compound speculation. What they do is speculation.
It's
What they do is speculation, it's on
Oh,
tape.
I'm gonna overrule the objection, so.
this should have been an
I can
easy
tell you no
overrule,
one pumped
Your Honor.
gas or went to
Your
the
left honor.
store.
Okay, thank you. So the state.
Yeah, no commentary. Let's just move on, okay? Thank you.
Jesus Christ,
Mr.
Judge.
Kokomo, thank you. Thank you. So while they were there, no one got out to pump gas. No one bought Sicko gas.
Sir, I just answered that.
And no one went into the store to buy any items.
That's an answer. Come on, let's move on, Mr. Sharp.
What?
Mr. Kokomo, could you go to 2205? Or my time? I think your time's a little different.
Yeah, I know it's Trinton. The judge sometimes just doesn't care if there is an objection or not. This is the judge's idea of saving time. It is by allowing a one-day witness be on the stand for 4 days for the prosecution and then not allow the defense to do a proper cross-examination.
And the blue car goes down Jonesboro Road, correct?
Yes, sir.
All right, pause it, pause it. Pause it, Mr. Kokomo. Okay, as it's, the blue car is left, we see OG Bentley, is he running to his car to give chase?
Here in this frame?
Yes,
No, he's right here. If we're looking at the bottom frame as well, he's right here inside the store.
so, kind of lumbering or walking slowly into the store,
He's seen in the store, the doorway of the store.
okay. All right, go ahead. Anyone running to any cars to give chase to that blue car?
You can definitely see Mr. McMullen waving them on, telling them to hurry up and come on.
Objection, counsel, speculation.
Your Honor, I would object because she's answering just the question that was asked.
That's completely non-responsive, but
All right, well, I'm gonna sustain Mr. Matthews' objection. You
Good.
you can go ahead and read.
More of that objection unresponsive. More of that from the defense. Because she will keep doing this over and over again. And the judge can only do that many horrible decisions before it gets too apparent that he is biased. We know it, but yeah.
Rephrase the question, okay?
okay. Now,
Thank you, DMAC. Thank you so much.
after Mr. Bentley and Mr. Allison leave the store,
Yes, sir.
they leave down Browns Mill Road, correct?
Yes, the silver Pontiac
And
goes
that's
down
a
Brown.
different road,
I was still answering.
okay?
To your first question, yes, the silver Pontiac goes down Browns Mill Road.
The White Nitro does too, as well, correct?
Yes.
Okay, and that's a different road than the blue car travels.
Browns Mill Road and Jonesboro Road,
Yes,
are they different roads?
yes. Okay, if you don't want to answer, you don't want to answer.
Objection to the commentary.
Thank you, Ghost Reed, but I can't say I'm unbiased because if you follow me long enough, you know I am very defense focused. Not as in defendant focused. I'm focused on the process so it is a fair trial. So yes, I have a bias towards the process and due process and fairness in the courtroom. And I see almost zero fairness towards the defense in this courtroom.
State of objection.
All right, so, you can take that off the screen, Mr. Kokomo, thank you. Let me ask you this. D'Angelo White. You aware he's in prison?
Am I aware?
Yeah.
I'm retired.
Do you know what he's in prison for?
Objection, relevant speculation, improper line of questioning for this witness, no foundation.
I sustain it.
All right, I want to talk to you a little bit about your interview.
She
with
was a
Walter Murphy
detective
on
while
August
he
18,
went into
2015.
prison. It's perfectly okay to ask that
Now, that
question.
August 18, 2015 statement, it was played, I think, this past Wednesday, correct?
One day last week, yes, sir.
Okay, and you would agree that that statement was not given in court, that was given in a conference room, correct? Or an interview room?
I mean, here for the August interview?
Yes.
Do you mean here or in one of our rooms at Atlanta Police?
The August 18, 2015 interview with Walter Murphy, where did it occur?
Atlanta Police Headquarters. You stated in a conference room here, and I thought you meant here in this building. Okay.
And Walter Murphy wasn't under oath. It is.
No.
All right. You talked to him about the April 2015 shooting and being at the compound, correct? April 26, 2015.
I believe Investigator Dennis spoke with him about the compound incident.
Okay, you were there?
During the interview, yes.
He indicated that he was very high at the time, correct? High off of Percocet and Xanax.
Objection as to characterization of how high.
I state the question as to form.
He indicated that he was under the influence of Percocet and Xanax that night, correct?
Objection.
How's that?
I'll rule the objection.
That night, at the compound, we were talking to him about it. He said that that night he was high on Percocet and Xanax, correct?
I don't recall him stating that night. Again, the compound incident, I'm not going to say I wasn't necessarily paying attention to him. That wasn't my focus, the compound incident. But any details about that, I mean, that wasn't my focus at that time. That's why I didn't ask.
Here's the difference between when she's lying, in my opinion, and when she actually knows something. When she actually knows something, she has no issues giving short answers. When she's lying, making stuff up, or just don't want to answer the question, she goes on a mouth diarrhea kind of thing.
Many questions about it.
Okay. He indicated that he went to Blue Ivory later that night.
Sir, any regards to this compound Lil Wayne bus shooting, I can't give you intricate details about what he said. That was not my focus on asking him questions regarding that shooting.
Okay.
If it's in the video, it's in the video, but.
Well, at some point, you and Investigator Dennis, both of you were asking questions, correct? And I understand your focus may have been one thing, Investigator Dennis' focus another. Is that fair?
Our focuses were two different things. We had the common goal, but that particular day you're speaking of, I had no interest in the Lil Wayne bus shooting.
You ever under any circumstances, whether it's as a police officer, civilian, undercover, have you ever been inside Blue Ivory, the club?
No,
Do you know what the inside of the club through pictures or videotape or anything looks like?
Yeah, I would object as to that question of cause speculation.
I'm asking if she knows.
If she
I'm asking.
knows, she just said she has. She said she has.
Oh, wait, just wait. I will overrule the objection. And I'm gonna overrule your objection.
Do you know what the inside of Blue Ivory is like?
I recall seeing photographs, but to give you intricate details of where what is inside, no. I've seen the outside several times. Inside, no, I've never personally been inside.
Do you know how many different rooms or dance floors are in Blue Ivory?
Sarah, I just answered that question.
That's enough?
I just answered your question. I do not know specifically intricate details about where stuff is, what's inside the club. I cannot give you details regarding that.
Okay.
So she have seen photos of it, but she's so rubbish at being an investigator and so clueless, memory loss, whatever, is that she simply doesn't pay attention unless the prosecutor asks her the question. Then she has perfect recollection.
All right. Fair enough. To your recollection, as being in the room, did anyone, when Walter Murphy indicated he saw things in Blue Ivory, did anyone specify where in the club Walter Murphy was, what room he was in, when he observed these things?
Objection, they didn't come out.
I stand the objection.
Do you remember Walter Murphy ever telling you exactly what room he was in within Blue Ivory?
Sarah, I don't remember anything Walter Murphy said regarding this Lil Wayne bus shooting and the events occurring around it.
Are you aware of a vehicle owned by, do you know who Alexis Greer is, also known as Dolly?
I've heard the name.
Okay. Are you aware of a Ford Explorer SUV owned by Dolly?
I may have heard that. I mean, I haven't seen it personally. I don't think I've asked anything about it that I can recall. So
Do you know what color that SUV is?
I don't recall it this time.
Okay. I'm going to move on from the April 26, 2015 incident.
April?
26, 2015. That's the compound. I said I'm
Okay,
gonna move
okay,
on.
okay. I didn't know which
It sounds
incident.
like you,
I didn't know which
respectfully,
incident
it sounds
was.
like that really wasn't your focus.
Correct. I didn't know which incident between April 26th.
Are these questions that Investigator Dennis should be asked?
Yeah, objection as to that, speculation. is-
I stand the objection.
And I'd ask that the lawyer allow the witness to answer.
Yeah, why isn't Inspector Dennis around answering questions about that? Could it be because reasons?
In the Dexter Montgomery case, you took over the case at some point.
Case was assigned to me, yes, sir.
Okay. And one of the first things you did is obtain surveillance from the Citgo gas station, correct?
One of the first things, no, that wasn't one of the very first things I did.
Okay, did you obtain surveillance from the Citgo gas station?
Eventually, yes, sir.
Okay. And last week,
So where is the rest of the report? Because clearly they found the surveillance video.
that you were able to contact someone who was able to obtain it for you, correct?
Yes.
Okay. And what agency were they from?
Atlanta
Atlanta who?
PD.
APD?
Yes, sir.
And who's the person that you contacted to go get that surveillance video?
Believe it was investigator Teague. He's with the Homeland Security Division, and his responsibilities are collecting surveillance video upon request.
All right,
Homeland
and that's what threw
Security.
me off. He's Homeland Security, but part of APD.
Yes, it's
Okay.
a division within APD.
And Investigator T, the Homeland Security, one of their functions is those are the people you call when you need surveillance, to find surveillance video in an investigation at your work.
That's who I contact when I need something, when I needed something. I don't know of all of his functions or
Okay.
job responsibilities.
And to your knowledge, no one needed to get a warrant to get the Citgo gas station footage, right?
Not that I'm aware of.
Okay, you just asked T to get it and he was able to get it,
I believe he had already had it.
okay? And you would agree that the video footage was a big part of your investigation, it was an important part of your investigation, correct?
Yes, it was.
It shows exactly the movements of people in the Citgo gas station that day, that night.
That's your question?
Yes.
Yes, it shows. Yes.
How, to your recollection, how long did it take APD Officer T, Homeland Security, to obtain the surveillance footage? If she knows.
I'll overrule objection. You can answer it, Matter, if you can.
I'm not certain.
Regarding the April 26, 2015 compound, incident to compound and Blue Ivory, I know that you said this wasn't your focus, but I'm going to ask you, did you ever call Investigator T or anyone from Homeland Security to obtain video footage from Blue Ivory on April 26, 2015?
No, I did not.
Okay. All right. Do you know of any other officers that attempted to obtain video footage from Blue Ivory on April 26, 2015?
I don't
In
know.
regards to the Lil Wayne bus shooting incident.
That was actually a Cobb County case.
And I'm asking, do you know of anyone that
Right.
attempted to obtain surveillance?
I'm not certain, sir.
All right, now you were involved in the investigation of the Donovan Thomas case, correct? The Donovan
I was
Thomas
not.
shooting?
I was not the lead investigator on that case.
I know you weren't the lead investigator, but you were involved, correct?
Involved in which portion of the investigation?
And then, did you do work as part of that investigation?
Is she asking him what part she was involved in? That's what she is supposed to say on that question.
Not necessarily, no.
Okay. All right, so you did no work on Donovan Thomas.
I sustain objection.
All right. You were present, and I'm not going to ask you what anyone said, okay?
Mhm.
But you were present when Kenneth Copeland arrived at APD headquarters on January 10, 2015, correct?
To the best of my recollection.
And you were let me just ask you this. You aware of a green store? What's called the Green Store in Atlanta on 490 Glen Street?
Yes.
Okay. You're aware that the Green Store has a camera system?
I sustain objection.
As an investigator for several years at APD, you've worked cases at the Green Store, correct?
No, I have not.
Okay, and so you have no idea whether they have a surveillance system at the Green Store.
I sustain objection.
As part of your investigations into the Donovan Thomas case, did you make any efforts to obtain video from the Green Store at 490 Glen Street as part of that investigation?
Sir, I just stated I was not the lead investigator on the Donovan Thomas homicide,
You don't
nor
have
have I
to be a
worked
lead
any case
investigator
at 490 Glen
to
Street,
ask for
Green
these
Store.
things.
Who was the lead investigator in the Donovan Thomas case?
Investigator Thorpe.
Are you aware of Investigator Thorpe making any attempts to get video surveillance from 490 Glen Street on January 10th, 2015?
Objection, foundation, basis, and speculation.
I'm,
Stand
I'm
objection.
asking if she's aware.
I stand objection.
You're aware of a McDonald's on Cleveland Avenue back in 2015? It's the corner of Cleveland Avenue and Old Hateville Road,
Yes,
okay? Are you aware, did you or are you aware of Investigator Thorpe attempting to obtain surveillance video from the McDonald's restaurant at Cleveland Avenue and Old Hateville Road for January 10th, 2015?
Objection, compound.
I stand objection to form.
Are you aware of anyone attempting to obtain the surveillance from the McDonald's for January 10th, 2015?
Objection, vague as to when they attempted.
I stand objection.
For January 10th, 2015, that surveillance footage.
that particular day or the day that someone went to that?
That particular?
Yes,
You attempted to obtain the footage
myself and Investigator Dennis did go to the McDonald's. Yes, sir.
to get the video footage from January 10th, 2015?
Yes, sir.
Where's that footage?
We did not get it.
Do you have a police report indicating that you attempted to obtain that footage?
The police report was not required.
You didn't. You went and attempted to obtain video footage in regards to a homicide investigation and you didn't write a police report about that?
Your Honor, I'm going to object.
Basis.
Foundation, mischaracterization testimony, she was not working on.
I stand the objection.
Your Honor, how can they say?
No, I'm not gonna speak. I'm stating the objection. You can rephrase it.
Do you have a
move
police
on.
report indicating that you did that work?
That's an answer. Move on.
Okay. Does Investigator Dennis have, to your knowledge, have a police report indicating you did that work?
I state the objection.
Okay. McDonald's had security cameras, correct?
I state the objection.
Your Honor, the McDonald's on Cleveland
I
Avenue.
state
and
the
Old-
objection. Move on.
Hey, she said vague, I'm making it clear.
All right.
The McDonald's on Old Hateful Road and Cleveland Avenue, they had security cameras, correct?
Objection, vague.
On January 10, 2015.
Okay.
So you want me to answer?
Yes.
It appeared to be video cameras on the outside of the McDonald's. Yes.
And to your knowledge, we don't have that video.
Objection, Your Honor.
To-
Some facts not in evidence.
To her knowledge,
Accidents.
I state the objection.
Nicholas Robinson, is an individual that you interviewed or you took part in an interview of, correct?
Nicholas Robinson.
The person who claimed his name was Nicholas Robinson.
I don't recall a Nicholas Robinson.
All right, on October 19, 2015, you and Investigator Thorpe encountered a gentleman who claimed to be named Nicholas Robinson, who came into the Atlanta Police Headquarters, correct? Claimed to have knowledge of the Donovan Thomas.
Are you talking about the young man? I believe his name was Spencer something. Are you talking about that incident? He didn't come just voluntarily walk into Atlanta Police Headquarters. So I believe your characterization of how it occurred is not correct.
Okay, he was arrested for felony charges and then told the police he wanted to come talk to y'all.
Now, I want to object. That's what you're saying. This witness, that person's.
I state the objection.
After being arrested for felony charges, did someone come to the police department to talk to you and Investigator Thorpe?
No, someone requested to speak with homicide in regards to the Donovan Thomas murder. I was not assigned to the homicide unit. So Investigator Thorpe spoke with him.
Okay, this person said his name was Nicholas Robinson, correct?
Objection, Your Honor.
Why don't you rephrase the question, sir? Do you know who the witness was that came in?
You asking me, sir?
Yes.
I believe his name was Spencer, something. I'm not sure if it's,
I want you to speculate, but do you know?
I don't remember. I don't remember the name that he initially gave. If you saying it's Nicholas Rob, I'm not going to refute that. I just don't remember that name. I remember Spencer.
Someone by the
Whatever.
name of Spencer Wright, is that?
I'm not sure of his last name. I remember his first name is Spencer.
Okay, someone by the name of Spencer came in, but initially they gave a fake name, correct?
I believe.
Objection, Your Honor.
Basis.
Speculation.
She just said,
I'll sustain this to form.
she just said he came in with a different name.
To the Zone 1 officers, yes, he did.
Okay. And when he started speaking to, okay. You testified on, I believe on Tuesday, that your practice when you're interviewing people is to make sure you get their name and date of birth, correct?
Yes,
Okay. And while this gentleman was speaking to Investigator Thorpe, you looked into the background of who this gentleman was, correct?
yes.
Okay. And you
And then-
discovered,
I'm sorry.
oh, go ahead.
It may have been after I spoke with him. I don't believe it was during the exact time as Thorpe was talking to him. I checked him out. I believe it was after I spoke with him.
Jesus.
Okay. And all this happened on October 19th, 2015?
That sounds about right.
Okay. And in you doing your due diligence to check who this individual was, you realized that he had been lying about his name, correct?
Yes,
And you alerted Detective Thorpe that this guy was lying about his name, correct?
yes,
And on October 19th, after you told Detective Thorpe about this man lying about his name, Detective Thorpe continued to speak to him, correct?
Objection, Your Honor. One,
Basis?
speculation as to what Detective Thorpe did. She was at relevance to foundation.
I stand as speculation. You can replace
Were you in the building
what building?
where the interview was taking place?
Yes,
Were you aware that the interview was taking place?
not initially, but eventually, yes,
Okay.
sir.
Well, I mean, you were aware because you were checking in the guy's background, correct?
After I spoke with him, yes, sir.
Okay.
That's what you're asking.
And when you realized he was lying about his name, you told Detective Thorpe, as we discussed, and Detective Thorpe continued to interview him, correct?
I can't tell you what Detective Thorpe did as far as his investigation.
The next day, after speaking to Spencer Wright, who gave the name Nicholas Robinson,
Mhm.
Detective Thorpe took out 4 warrants for the murder of Donovan Thomas, correct?
Yeah, I'm going to object.
Basis?
Foundation, basis, speculation, this witness, this process.
I state the objection.
Okay. You aware that Detective Thorpe took out warrants the next day?
Objection, same.
I state the objection.
Detective Thorpe, when he, on October 20th, 2015, took out warrants for Shannon Stillwell.
Objection, Your Honor, for the same reason.
I state the objection.
You've seen the surveillance of the Donovan Thomas shooting? On McDaniel shooting?
I'm thinking. I believe I saw it on the news.
All right,
Like on the news.
Charlie, need to put a pause in there. We need to take a comfort break. All right, ladies and gentlemen, we're going to take a comfort break. If you could come back for 11:45, please, and we'll be in recess until that time. All rise.
This is insanity, the way the judge does not allow the defense to ask proper questions. And he tells them to move on. When he refuses, after the commentary from this witness, to do something about it, anything, he refuses to give Mr. Short a fair chance to conduct a cross-examination of a person this judge allowed in as both an expert witness on gangs and a fact witness, and he's asking questions about investigations she was involved in. It is... Yeah, I mean, Judge Glanville has been bad this far. But during this cross-examination, he's unfit to do any judgment calls. Yeah. But this witness, as Heather Moshe says, or where was it? No, Reformed Convict says, during her direct examination for 4 days, she could testify about everything. Speculations, everything the prosecution wanted to ask her about. opening their own doors to evidence that shouldn't have been allowed in. And then Judge Glanville, the coward, the spineless piece of garbage, is actively denying the defendants their right to a fair trial. She's testifying about events where their reports are missing. And even though, oh, those reports, we can't find them, blah, blah, blah. Coincidentally, the prosecution pulled video footage from that investigation. They pulled the lineup photos from that investigation. But coincidentally, the rest of the investigation is just gone. Exactly, Reformed Convict says, how can you impeach a witness when you can't ask questions? I agree. It is unbelievably bad. Now, I do know Judge Glanville, high rank in the military. He helped. He was stationed in Afghanistan. One of the things he did there was to set up the new Afghan justice system to help them with that. Now, since then, the Taliban has taken over, and they are using that system he set up to find women, children, intellectuals, anybody the Taliban doesn't like, in order to hunt them down and prosecute them without due process, and then they go missing. That is Judge Glanville's heritage, what he leaves to the afterworld to remember him by. And this trial, where he is clearly unfit. I don't know what Prosecutor Love has on him or anything, but this is so bad. Yeah, I know, Brigadier General Ural D. Glanville. I don't know what to say. I need to fill up my drink bottle. Let's listen to the Fannie Willis song while I step away for a minute too.
Crooked Fanny playing dirty tricks in the courtroom. She always picks, bending the rules. She know it, but I won't let her get under my skin. Down in Georgia, where the blues run deep, crooked justice, a secret they keep. But I see through her lies, I see the truth. Gonna make her pay for what she do. Fanny's got a reputation to uphold, but her tactics are shady. Story untold, she thinks she's clever, but I'm on to her game. I'll expose her ways and put her to shame.
Oh, I forgot to turn off the sound.
Crooked Fanny playing dirty tricks.
All right. Jesus Christ. While we wait for the things, let's go back and listen more to what happened on Wednesday. Dun, dun, dun. There it is. And There it is.
Letter C in terms of,
Yeah.
okay, hold on one sec.
It's in, under Roman numeral 3, it says discussion. And then it starts with A, B, and then C, and then 1.
I'm with you.
Okay, and then, I mean, it's a short passage, we could read the whole thing, but I liked it because it targeted both what you said to us, and I heard what you said after I found it. But 801 D2A as well as 801 D2E, that was in the same case. And in the third paragraph of Division 1, it states that the district court also acted within its discretion when it concluded that circumstantial evidence coupled with Rodriguez's self-identification authenticated the telephone conversation sufficiently to satisfy.
Yeah, listen till. Her comment there is that's the jury's job. And she knows it, this witness. She's cop. She's a cop, or was a cop, a really, really lousy one at that. But she still had testified in court before. She knows she can't do that. And the judge did nothing about it.
By Federal Rule 901, which is corresponding to Georgia 24-9-901, which provides that the requirement of authentication or identification as a condition precedent to admissibility is satisfied by evidence sufficient to support a finding that the matter in question is what its proponent claims. And that's what the court just found, and what I've been saying, they don't have, to my knowledge, right now, any evidence that this repost is what it was originally. They don't have the date on the original statement. So that is my position again.
Yeah, sadly in Georgia, they have a statute which is more recent, where the Georgia Supreme Court just pulled down their pants and pissed on prior statutes by allowing evidence in by the pure allegation it is a party opponent, it is a party admission. And I did not think I did not believe until I heard that any court anywhere in the Western world could be that stupid and that so against fundamental rights to a defendant, to a property. It violates due process, in my opinion. And yeah, everything. Heather Mosher, how is that constitutional? I don't know. It hasn't been, that case has not, that rendition of the case law has not been challenged in the Supreme Court or the Supreme Court of the United States. So until they bring up a case where that happened, they can't rule on it. My creaky chair. Now I have bought a new chair. It's called a Diablo something. It's supposed to hold for 400 pounds and great reviews. I just need to get it from where I ordered it. Let's keep listening to this until we get back to the after the comfort break.
62A, which is our statute, it has no requirement of date and time as Mr. Steele is asserting.
Authenticity.
And specifically.
That's
Grifting time calls. Well, if you would be inclined to support my channel the monetary way, you can super chat, you can gift memberships, you can become a member, or you can go through PayPal. And if you choose to become a member, it's $3 a month, and you get access to all my members only content. And I have so much. And you also get access to my Discord, where you can keep talking about the cases I'm following. So now, don't spend money you don't have. If you're choosing between bread and giving me $3, choose bread. But for you who thinks, yeah, I've been seeing this guy around now for a while, $3 a month. And you get access in my members only content. It is about the farm. It is about the renovation. I have a tractor that says fork. The license plate spells FCK. And it's one of the reasons I actually bought it. Oh, thank you, Nana Misty. Thank you so much. Nana Misty gifted 5 memberships. Thank you so much. It was gifted to Dead Ringer, Sherry, Will Call Magic, Denise Sells, and Steve Keat. Now, if you want to be eligible for being gifted memberships, on the top of the YouTube chat, you see a gift box with the number 5. If you press that, you will get somewhere there, you will get the option to receive gifted memberships. Or you can choose this way. If you're going through Apple, you need to go out of the app and into a web browser, I think. I'm not entirely sure. I'm old. I don't have everything with this computer stuff correct. Dead Ringer says, hey Nick, I can't find any case law that allows the state to basically gaslight the jury to get a conviction. It's called Georgia RICO. It's so broad and so vague that in order to be associated with a alleged criminal street gang or criminal enterprise, in the statute, that can be both verbal and non-verbal agreement. It's that vague. Let's keep.
That's different. Authenticity is different.
Exactly.
Authenticity is different. It's 901.
It's the authenticity of RICO.
Okay.
I'm not saying.
But okay, but Mr. Sale, that would only be, for example, if I couldn't or nobody could make out that that's purportedly your client, that would be indicia that it's not reliable. Okay, but there's nothing in there that's shown that the postings have been distorted. It's not readable.
Listen to what the judge said here. What he says is the burden of proof is on the defense. That is what he's saying. Just because he can't see by his bare eyes that that particular video has been altered, then it should be allowed. Here's the thing. That kind of video should be the foundation should be laid out by an expert in that field in order to have it admitted. Problem is that Georgia has a statute that says, no, you don't need that. Because the Georgia Supreme Court or the appellate court or whatever, whoever did it, thought, no, let's make our prosecutors are so lazy, incompetent, and they cheat, and we like it that way. So we are going to give them more weapons and deny basic constitutional rights to the defendant, so we can get a few more convictions. Steve Keat, isn't burden of proof meant to be on prosecution? Yep. The burden should be on the prosecution to lay the foundation for allowing this video they are talking about to be entered into evidence. But the Georgia appellate court says no, don't need it.
It's grainy, whatever. So there's sufficient indicia that that's your client. I mean, I would argue that from looking at what.
But here's the thing: it's not his posting; it is a repost. Now, if there are thousands and thousands of videos out there on the YouTubes where audio has been switched. The way people move their mouth still fits the words, but they are saying something completely different. That is why this repost must be, or should be, gone through a process. But in Georgia, you don't have to, because by the pure claim, it is a party admission. It is allowed in. Yeah, and hit the thumbs up while you're here. And if you haven't subscribed yet, please do. I would really the chat. I mean, we all go on the YouTubes. We do this because if we stop growing, YouTube thinks people don't like us anymore, and then they stop promoting us to more people. So that's constant growth, or at least people coming in as new subscribers. So if you wouldn't mind, I would greatly appreciate it. Thank you so much.
What the state has tendered or proposes to tender as in this exhibit 111, I should say 112 Bravo.
I'm not claiming that someone reasonably did not say that's.
But that goes to 901, and it goes to whether or not it could reasonably be that it's your client and there's other and it's reliable. So.
Is there something beforehand? Is there something after? The words change. The other speakers are unidentified.
But there's nothing in there that would indicate to the court that has occurred. If there was, I would certainly take your argument.
But it is the prosecution's evidence. They have to put the evidence forward. Just because you don't see it. Because when we watch, sadly, this judge allows it and they play it, and it is cut off mid-sentence. Mid-sentence. It starts mid-sentence and it ends mid-sentence. And this absolute jackass claims he can't see anything about it. Maybe because his head is full of snot. Maybe, or it's just that he really, really wants a conviction out of this trial. Exactly, Heather Mosher. How can he know if he hasn't seen the original?
And that would be more applicable. But I understand, sir. I'm gonna basically overrule that particular. I'm not gonna overrule it, but I'm gonna go ahead and I'm considering it for the proposition. It is.
Your Honor, in regards to the statements of other people on that video, those are not admissions by Mr. Williams. So are those being redacted? I recall, despite what was said at the bench, that the tape actually, I think at one point, someone says this is from YSL, B word, or something like that. And those are not words of Mr. Williams.
Okay, but Mr. Williams, if you believe the state's argument and the jury can decide for themselves, he's co-opting that particular person's statement as to the circumstances.
Well, and I have an argument about that. Essentially, what we're talking about under the law is the case law refers to as an adoptive admission. And two things.
Well, no, it's different because you're still dealing with statements of a party opponent, okay?
Right, but if it's not the person, if it's not the party itself making the statement, then the only way it's admissible is if it's adopted by the party. That's what an adopted admission is. And according to the 11th Circuit and the case law, it's very limited case law in Georgia, but two criteria must be met. First, the situation must be such that the innocent would normally be induced to respond to the words of the other person. And second, there must be sufficient foundational facts from which it can be inferred that the defendant heard, understood, and acquiesced to the said statement. And this is my argument. It's going to be by analogy. I'm on the phone with Mr. Steele. We're talking about the day we were in court, and then Mr. Steele says, and Max, remember that armed robbery that we did in 2020? And then he hangs up the phone. Well, I didn't have much of
That's a little different. Hey, because that's called a tacit admission. That's a statement that somebody, listen, that's a statement that somebody makes that you expect them to say. It's just.
Yeah, and then it goes on and on. But they are back. So we are back on live and from today. Once we get to lunch, if we get there. If we get there to lunch, then we will play the rest Wednesday.
Ladies and gentlemen, please be seated. All right, thank you, Sergeant Ingram. All right, Mr. Sharp, go ahead.
This court. Investigator Gaither, to my recollection, I last asked you about the surveillance video from January 10, 2015, the Donovan Thomas shooting.
Okay.
Have you seen that surveillance video?
I believe I saw it on the newscast, not the actual video that investigators retrieved, or are you just saying period?
Either one.
I believe I saw like a clip.
So the surveillance video existed. The surveillance video, the prosecution claims nobody gathered, was played in the news.
Of it on the news.
Have you ever seen the gentleman who now we know is Spencer Wright? Have you ever seen him in the video being on the scene?
I believe I saw the video, a short snippet of it on the news, like the vehicle driving by. I don't recall any particular persons or anything in the video, just the vehicle.
Fair enough. You know an individual by the name of Kenneth Copeland, correct?
I do.
Okay. And I'm not going to ask about what was said to you by Mr. Copeland, but I am going to ask about the times you've seen him. Okay. You saw him on January 10, 2015 at police headquarters, correct?
It's either the 10th or the 11th.
Either 10th or 11th, night of the 10th going into the morning of the 11th, correct?
Correct.
All right. Was that the first time you had ever met or seen or interacted with Kenneth Copeland?
No.
As
Okay,
an
that's interesting.
investigator, you give out your phone number to people in the community from time to time, correct?
Are we speaking about something specific or?
You give out a number for people to call you, if they have information, things like that.
I have, but it's not a general practice where I just hand out my phone number.
Okay, do you, at that time, I'm talking 2015, when you were still with APD, correct?
Mm-hmm.
All right. Did you have like an APD work phone, or did you operate off of your personal cell phone?
I had a work number.
Okay, you had a work number.
Yes, sir.
As part of your investigations in 2015, you gave, Kenneth Copeland had your work number, correct?
After, I want to believe it was the second interview. If you're speaking around the time of the homicide, that January time, no.
Okay. Now, he was arrested in June of 2015, correct?
I believe
On
so.
federal charges.
I believe so.
Okay. Sometime between January and June of 2015, you gave him your number, correct? Your work number.
It was definitely after January. I believe
Okay.
it was after January.
Did you have phone conversations? Again, not asking what was said.
Mhm.
Did you have phone conversations with Kenneth Copeland in January of 2015?
I don't recall. I'm not saying it didn't happen. I can't recall at this time.
Do you have any reports documenting these phone conversations with Kenneth Copeland?
In my possession today?
Yes.
No, sir.
Do you have any recordings of your phone conversations with Kenneth Copeland?
In my possession today?
Yes.
I don't have any information as far as reports, recordings, police reports regarding information that can have.
Well, she doesn't have it because the
How about February
prosecution
of
made it
2015?
disappear.
Do you know how many phone conversations you had with Kenneth Copeland on your work cell phone in February 2015?
I don't.
Do you have any recordings of these conversations?
I'm not sure.
Do you have any police reports regarding these conversations?
I'm not sure.
Okay. March 2015, same questions. Do you have any documentation of the phone conversations you had with Kenneth Copeland?
Yeah, same answers.
Okay. What about April 2015? Do you have any police reports or recordings of the phone conversations with Kenneth Copeland?
Same answer.
Do you know how many phone conversations you had with Kenneth Copeland in April 2015?
I don't.
How about May 2015?
I don't recall a number that I've ever spoken with him as far as the time frame and the exact number.
June 2015, before his arrest, do you know how many phone conversations you had with Kenneth Copeland?
I don't recall a number of phone conversations ever for Mr. Copeland.
Okay, and do you have any police reports summarizing how many phone conversations you had between Kenneth Copeland and your work cell number from January to June of 2015?
Here with me today, no.
Which
Where would those reports be?
I haven't.
If you know,
I sustain the objection.
do you know where those?
I sustain the objection.
Okay, did you write reports about those things?
I believe some of the information was documented, yes, if we were speaking about a particular investigation.
I'm not speaking about the investigation generally, I'm talking about these phone conversations.
What is your question?
Did you write reports regarding the phone conversations?
I sustain the objection, Mr. Form.
Did you have any reports regarding the phone conversations between you and Kenneth Copeland between January 2015 and June 2015?
Are you speaking about a particular incident?
I'm just.
I don't want to speak generally to you.
Any phone conversation that you had, did you write any reports?
If you're speaking about something specific, you can ask me something specific. So
Okay, well,
I don't want, I'm still answering. So I don't want to answer you generally because I don't want to give the wrong or mischaracterization of my answer. So
Okay.
If you're asking me something specific, I can ask something.
I would like to be very specific.
Okay.
What date did you have a phone conversation with Kenneth Copeland in February 2015?
I don't recall a specific date, but I've had phone conversations with Mr. Copeland several times between January and June.
So, and did you write reports?
Are you, again, asking about something specific?
Specifically on February 22nd of 2015, did you have a phone conversation with Kenneth Copeland?
Was that a particular incident that occurred that day?
No, can I have your reports?
Yeah, I object.
I state the objection.
Here's the thing. He has to lay foundation. And she refuses to answer very simple questions. Did you write reports about your phone conversation? And she refuses to say generally because she knows that would lead to specifics. So she demands of him to go to specifics, which he can't do because he has to lay foundation for it. And the judge allows it. He allows this he allows this witness to lie. Because how she answers these questions, how she evades answering them, tells me that she knows exactly what conversations he's talking about, but she refuses it, and the judge helps her.
You're working a different job today than you were in 2015, correct?
Yes.
Okay. But in preparation of your testimony, you did have phone conversations with the prosecution team about the plans of you testifying, correct?
I've spoken to Ms. Love, yes.
Okay. Have you spoken to other members of the prosecution team?
I may have spoke with Simone once.
Okay, was this
Ms. Hilton, I'm sorry.
in person or on the phone?
Objection, no.
The witness availing themselves to prepare for testimony? Shows bias?
I'll rule the objection.
Is this in person or on the phone?
Majority of the time over the phone, if I was available.
You said the majority of the time. Approximately how many phone conversations?
Since the start of myself coming into court,
No, since they started calling you potentially as a witness to prepare you to testify.
I may have talked to Ms. Love twice since my time that I've been here testifying. I've spoken to her more often, but I'm really not available to be on the phone during most times because of my job.
How many in-person meetings?
With Ms. Love?
With anyone from the prosecution?
Again, can you be more specific? Do you mean since my testimony has started?
No,
One.
since this case started.
I don't know when this case started. For me, it started 2015.
In the last year, regarding this case,
Mhm.
how many in-person meetings have you had with members of the prosecution?
I may have met with Ms. Love once.
Okay. Is that in addition to the one time you said you met since your testimony started?
No, I see Ms. Love every day that I'm here.
Okay, so you talk to her every day that you're here as well?
Yes.
Okay, so, for instance, I believe it
This
was
is
on
Ms. Love
Tuesday,
probably
you
instructing
were asked, the first questions you were asked
and
were to
helping
clarify,
this witness to be
telling
evasive.
Walter Murphy that you were gonna give him a chance to sober up. Remember that?
Yes.
Okay, the state spoke to you about that the day before and said, hey, you said sober up, we're gonna ask you about that, correct?
I don't believe so.
Okay.
I don't recall if they did.
You're aware that the defense attorneys
Mhm.
were also seeking to speak with you prior to your testimony, correct?
I believe Mr. Steele reached out.
Okay. Mr. Steele wrote you an email hoping to speak with you, and this was around December of 2023, correct?
Object to any questions about what someone else did.
I stand the
Your
objection.
Hearsay.
I stand the objection.
She's an expert witness.
But you can rephrase if you like.
Okay. As a witness,
She's an expert witness who refuses to talk to the defense. That should have been a disqualification before she even entered the courthouse, in my opinion.
Mr. Steele reached out to you about talking about the work in this case, correct?
The work in this case, or that he wanted to speak with me about regarding this case?
About the work you did in this case.
Oh, I didn't hear you. I couldn't understand. You said the work you did. I didn't.
Yes, the work you did in this case.
He stated he wanted to speak with me in regards to the case. He didn't say a specific reason.
And initially, there was going to be a telephone call to discuss things, but eventually you said that you did not want to speak about the work in this case to the defense side, correct?
No, you're incorrect.
Okay. I'm going to.
Did she just lie on the stand? And remember, this is the prosecution's expert witness who refused to talk to the defense. Yeah. Witnesses can talk to attorneys in this case. That includes prosecution and defense. I assume, because Ms. Love is unethical and has no soul, that she has told, after direct examination, she told this witness to never answer a question. I will help you through it. I will object because I do reach around on Judge Glanville and he will do as I say. That's me speculating.
Coach, John?
Yes, you may, sir.
Okay, I'm gonna show you an email.
Y'all know what that was identifying it, just stick with the number.
DS13, Your Honor.
All right.
Is that an email you sent to Attorney Steele on December 28th of 2023?
It's part of it. You missing a little bit.
Okay, you can put down.
Are we looking at just the first page, or are you said?
You can look at the-
Oh, I'm asking a question. You said, is this an email that I sent to Mr. Steele? Is that what you asked? Okay, this is a portion of an email chain.
Right. And
Okay.
you can look at the previous
Okay.
pages.
What am I looking for?
Just to make sure that you feel that it's an accurate representation of the email.
Yeah. Remember, she was proffered as an
I believe this is
witness.
accurate, but your characterization of what I said is inaccurate.
Okay, well, we're going to talk about exactly what you said.
Absolutely.
In the previous pages, Mr. Steele was trying to set up a meeting to speak with you about the work in this case, correct? Your work in this case, correct?
Correct.
All right. Could you read the email on that top page?
Judge, I'm
Did
gonna
they-
object.
Basis.
You say reading the document, not an evidence.
The prior consistent statement.
It's foundation. I'll sustain this to that. I sustain objections to that.
Okay. Is this an accurate depiction of the emails that were exchanged between you and Mr. Steele?
It appears to me, it looks a little out of order, but for the most part, it appears to me.
Your Honor, at this point, at this time, I would ask to admit DS13 into evidence.
Objection.
Yes, Your Honor. It's
Basis.
The hearsay not inconsistent.
I sustain the objection.
Oh, you fuck.
Investigator Gaither,
Yes, sir.
on December 28, 2023, did you write, "Good morning, Mr. Steele. I have decided not answer any questions at this time. Hopefully, you are able to find answers to any questions you may have in my corresponding police reports. Is that what you said?
Oh,
That is what I emailed after
oh,
Mr. Steele was given an opportunity to call me and meet with me, and he did not meet that time. So therefore, I was not gonna keep rearranging my schedule because he did not meet that time.
Hopefully, you are able to find answers to any questions you may have in my corresponding police reports.
Mhm.
Mr. Gaither, where are your police reports?
Objection, Your Honor, asked and answered.
Outstanding objection.
fuck no.
I have no further questions. Thank you.
That, when she writes in an email about correspondent police reports, that is her admitting they exist. So, asked and answered, yeah, she lied under oath on the stand about those police reports.
All right, ladies and gentlemen, how about we take some lunch at this point in time? Go ahead and continue with the third.
And they went on lunch. Comfort break, 15 minutes, lunch. Yeah, she lied. Jesus Christ. And the judge still helps her. Lying. The judge just helped this witness to lie under oath on the stand. This is... The judge has been really bad up until this cross-examination. Now, I don't know what end of a gas tank he sniffs. But Jesus Christ. I mean, for instance, in the Delphi case, which I also cover, that judge is seriously unethical. But Judge Glanville, what he did here during cross-examination, yeah, it's on par. And that judge, Judge Gould or Judge Gull, was reprimanded by the Indiana State Court, Indiana Supreme Court. But this judge is the chief judge of Fulton County, and he shouldn't even practice law out of a cupboard in a Thai massage shop. She lied. She was confronted with it. She lied about these reports. She knows they exist. And on the stand, she says, I don't know. And also, this means that Prosecutor Love has lied to the court. Yeah, it goes. It sounded almost as the police reports were attached to the email. Correspondent police reports. Here's the thing. With the question from Mr. Shaw, where are those police reports? Now it was sustained by asked and answered. No, Judge Glanville, you absolute buffoon. It wasn't. But you are so deep into your own asshole that you stop caring about law, due process. I don't know why. I don't care why. But this is... okay. let's finish off Wednesdays. And then this is what's going to happen. I will play the afternoon tomorrow as a recap until we catch up, because I have work to do myself. Sadly, I came home from work, I do this for 3 hours, then I have to do work, prepare for tomorrow. For you who are completely new here, hi, I'm Nick. I do labor law. This means I actually have a law degree, and I am trained in evidence evaluation, negotiations, mitigations, all of those things that comes with being doing labor law. So let's finish off Wednesdays, and then I will do a off I fork, because I need to work. There you are.
It's like, you know, the like somebody who says, you know, did you hit Frank? I didn't.
Well, right.
You'd expect somebody to deny that
Correct.
immediately.
Correct, but from my
We will
recollection,
watch.
watching the
It's
watching the
a part
post,
of what we are watching now.
that
Wawa.
last part was said at the very end of the post, and there was really no opportunity to respond, to acquiesce, to do anything. And then the post ended. So my argument is, you know, I agree with Mr. Steele that it should not be admitted at all, and that's my stance. But if it is going to be admitted, the words of a third party, I don't believe that Mr. Williams' lack of chastising the person, whoever said it, in the 1 second that the clip continued before it was turned off, constitutes an adoptive admission. And so
All
that's
right.
my stance.
Thank you, sir. All right, State, you wish to be heard on that issue.
Yes, Your Honor. What is happening, as the court heard, is that the person who is echoing Mr. Williams' comments about people who come into court and tell the truth need to get killed, that's from him and YSL. They're actually echoing Mr. Williams' statement, as opposed to Mr. Williams' statement simply adopting his. The other thing that I would point out is that this is a much different situation than, say, someone taking a selfie and getting photobombed unknowingly by Mr. Brown standing behind me until I look at the picture. Mr. Williams has a camera up to his face. He is video recording himself, and it's audible to a listener that words are being spoken. He did not have to keep that recording. So his nonverbal conduct was the recording of himself and the capturing of that echoing or that co-signing of the person who is signing on to what he just said. It's not a simple matter of Mr. Williams adopting or not adopting the person behind him. It's the person behind him echoing and adopting his admission. And by recording himself and that person on that video recording, Mr. Williams is essentially signing on to the sign on, if you will. He is agreeing with what that person is saying. They're synonymous. Snitching bitches is the last thing I think that someone said. And that is essentially the same as you come into court and tell the truth, you need to get killed. That's from me and YSL. And so, as stated earlier, Your Honor, under 24-801 D2A, given the definition of statement as both an oral assertion and as a nonverbal conduct, the oral assertion qualifies as a statement that Mr. Williams is making, that a person who comes in and testifies should get killed from him and YSL, and the nonverbal conduct is recording himself and the person co-signing with him on a videotaped medium.
Your Honor, the state in their argument just made a whole bunch of assumptions that there's no evidence to support. They just stated that Mr. Williams was hitting himself. I don't know how we can make that determination. They said that Mr. Williams decided to post it himself. I don't know how we can make that determination. And that's the whole point. We don't know these things. There's a lack of foundation.
In terms of what, sir?
Well, I mean, they just said that Mr. Williams taped himself. I'm not agreeing to that. They're saying Mr. Williams chose to post it on the internet. I'm not agreeing to that. So these are the foundational requirements that they're just kind of stating it as so, but I don't believe that that's been proven. So, and that's relevant to the issue of the adoptive admission part, or as you called it, I think we're talking about the same thing. You called it tacit admission, I call it adoptive admission. I think essentially we're talking about the same thing.
Sir, I'm sorry.
I will say this, I don't personally have any knowledge that this is on Mr. Williams' social media. I've looked, I cannot find it. If I'm wrong, I know the state didn't give it to me. Discovery like that, and I don't find it. And I'm not going to repeat myself, but, we started this whole thing with, there's no other person in the background except yay, yay. Now other people are saying things in the background, but it shifted so much. And I just still think that the bottom line is somebody, the proponent of the evidence is the state of Georgia. Somebody has to come in and say, yeah, this wasn't altered. This is when it was made, and this is accurate. And we don't have that. What if this was made, Your Honor, in 2014? Just for instance.
But the challenge is that under current Georgia law, as it pertains to admissions by a party opponent, it's admissible without presentation of predicate or foundation. Unlike if you have a statement against interest, or unlike if you've got conspiratorial statements, there are a couple other things that need to be brought up. But this particular statement is being offered for the admission by a party opponent, and that's what the law provides under 24-8-801 D2A.
Not really, because if you recall, it's posted, the state said it's being offered as a statement also of a party conspirator, of a co-conspirator, excuse me.
Okay, that's different. That would be under E.
Right.
And E requires different, but however, looking at E as well, conspiracy need not be charged in order for OCGA 24-8-801 D2E to apply. For evidence to be admissible under this rule, the government must prove the existence of a conspiracy by preponderance of the evidence. In considering whether a conspiracy exists was established for purposes of this rule, courts do not require the conspiracy to be proven prior to the admission of the evidence in question, but only that the conspiracy was proven at trial. So, but their primary purpose is under 801 D2A.
Please correct me, but I believe the foundation is needed because remember how the state is using it is they're saying they charge it like this. They put it in the overt act. I think you said 26. I can't remember. I think you said that. They put it as a repost or posting by Mr. Garlington. It's not Mr. Garlington's statement. They're saying that it's Mr. Garlington's statement to warn people because they're in a conspiracy, so it's a co-conspirator statement. So I still believe that the statement originally by Mr. Williams has to be authenticated, as we've been discussing.
The law does, I don't think it does. I mean, there's nothing in here that says that statement has to be authenticated. It just says co-conspirator statements may be admitted when the prosecution shows by a preponderance of the evidence that a conspiracy existed. 2, that a conspiracy included the declarant and the defendant against whom the statement is offered. And 3, the statement was made during the course and in furtherance of the conspiracy. Where statements, however, admit participation in crime but do not evince an intent to commit further criminal activity, Rule 801 D2E does not authorize their introduction. I would submit
That
from
is
the court's perspective that
the
the
appellate
statements
court
could be considered
system
by the
is relying
jury
on.
for the other purposes of
You don't need to authenticate
what
it.
your client
You don't
said
need
about
to lay
people
foundation.
coming into court,
No, nothing.
making
All
purported
that's
statements.
needed
So
is the prosecution
I believe that
saying,
it would satisfy
it's
still the
true.
dictates of 801
Trust me,
D2E.
bro.
But remember, the state's offering it under 801 for count 26, but also for the overt act under count 1.
So
And I'll give that, we can hash out that when I charge the jury. Well, because it's going to depend upon some other things if we get to that point, and some other things that may develop in this case. So I'm not saying to you that we may not have a distinction between that, but at this point, I believe it'd be admissible.
okay, and listen, I respect your ruling, but that's why I found the Rodriguez case, because it discusses both 801 D2A and 801 D2E in the same C1 section, and they discuss specifically the authenticity under 901. That's why I thought it was a good case.
Yeah. Here's the thing. Before this part, the judge was actually denying the state the use of this. Then they had a break for 15 minutes. And then all of a sudden, Miss Love found another way, and the judge buckled, as he always does. Because if you have no spine, you always buckle.
Okay, I understand. State, have any further comment about that?
Your Honor, we believe 24-801 D2, the evidence.
States 112 correction. Okay.
Your ruling done. Here, now this you need to listen to.
Sure.
This you need to listen to. If you haven't heard it already, you need to listen to this.
And I just need about 3 or 4 minutes. I've got to say this because I've been sitting there after our conversations. Let me just preface it by saying, in any of our objections, whatever, you make a ruling. Sometimes we win, sometimes we lose, we move on. That's fine. If after your ruling, I've got a case that I want to bring to your attention, I say, Judge, reconsider your ruling based on this case, and you consider it, that's fine. If you don't want to consider it, that's fine too. But what I found objectionable, and I want the court to address with the state, is what happened at the bench earlier. There was an objection to the video, you made a ruling, we moved on. The state came back up and made representations to you. And they weren't representations based upon some new case law that they had found. There were representations, misrepresentations that were made directly to you, all of us standing there right there at the bench. She said something very, very fact specific in an attempt to get you to readdress the issue again. Madam Prosecutor said, I want you to listen to the 17-second video, because what you had based your ruling on was that the parties in the background couldn't be identified, right? And Madam Prosecutor said to you, and was not accurate, and I'm gonna be charitable and say that she was disingenuous. What she said was, these people in the background, the only thing that you hear are people saying, yeah, yeah. That's it. When Mr. Steele corrected her and said that's not true, she said, Mrs. Steele is not accurate. What Mrs. Steele just told you is not true. The only thing you can hear in the background is yeah, yeah. And actually, when she stepped up there, it was in an attempt to act as though she didn't know what your ruling previously was, because their attempt was to go ahead and play the video at that time, despite your previous ruling. My point is this. After you decided to reconsider, you want to hear the video yourself, you had a chance to hear it. You had a chance to hear what we had already heard, what we knew it said, what they knew it said. And there are at least 5 or 6 different things on that video audio that were in contradiction of what Madam Prosecutor said. On God, snitching bitches. I'ma tell a lie on God. That's what I'm talking about. No back and forth with you, bro. Fuck nigga. I'm not just saying that for emphasis. I'm saying that because what she said to you was inaccurate. At some point, Your Honor, I'm asking you to, we've had this conversation about candor with the court over the course of the past number of weeks.
3.3.
Yeah, we've had that conversation about it. And when we step up to you and we make a representation, it ought to be candid and it ought to be truthful. And what she said, and look, if she wins the motion, ultimately she wins. But you don't do it by standing there 3 feet from you in your face and lying to the court. And that's what she did. And she knew what she was doing, and it's not right. You heard Mr. Steele. Mr. Steele said, Your Honor, I am willing to surrender my bar card and have her surrender her bar card if what she is saying is true. He wasn't wrong. She wasn't wrong. She was not candid with the court. And at some point, you've got to say to the parties, if I've done that, I would expect you to say, Mr. Adams, don't do that again. Don't step up to me and lie to try and get me to rule or overrule something I've already ruled on.
He would put you in jail for that.
You ought to say that to them. We're not playing games in this courtroom. These are these people's lives at stake. And like I said, sometimes you win a motion, sometimes you lose. But you don't get the court to address something or readdress something like that. That's all. Say something to them is all I'm requesting.
All right, sir.
Yeah, she lied. She knew she lied. And here's the thing. Here is how I know this person is empty inside, that she has no soul. There's nothing. She's stuffing herself with garbage because she's so empty inside. No soul whatsoever. It's impossible for her to have a soul, a conscious, anything? Because listen what she says now.
You may.
Your Honor, I would not have asked the court to listen to the 17-second video.
But what you did tell me, Ms. Love, wasn't the entirety of what was purportedly on.
And here the judge starts making excuses already. What you said wasn't the entirety of...
On states 112 Bravo. It did have other statements on it. It's different if you'd have told me, Judge, there are statements on there. Probably need to listen to them for yourself. Not just yeah.
Your Honor, my recollection, and I'm going to speak candidly because it's been.
I would hope
along.
there'd be nothing less than candor.
And Your Honor, that's what I've been pushing for all along. There have been times, as the court is aware, that we have been at the bench and misrepresentations, bald misrepresentations have been made, and the court has seen my reaction to them. I am the one that's constantly saying I have a duty of candor.
Miss Love is again right there lying to the judge. Here's my theory. The judge knows she's lying, but he doesn't care. But why? I can name a few reasons. None of them will probably get this stream demonetized. Most of them, if not all of them, will get this stream demonetized. If it's not already. I haven't checked for a while. Yeah, so now she's lying to him again. Because she has no soul. She does this without a without a thought. She just, let's cover up my lie with more lies. And if you watch my video from yesterday, where this prosecutor, Adrian Love, actively, in my opinion, put a young boy in Fulton County Jail, and he passed away in jail. And he was put in jail because she lied to the court and to a jury in a competency hearing. Because that's what she does. She does not care about justice. She cares about winning. And when you go to such degree to win, you have no soul. Nothing. It's a shell. I can't wait to get to Atlanta in August and visit this courthouse, hopefully during an actual trial day. I can't wait. I hope both Judge Glanville and this thing sees me. I don't know, they might throw me out of the United States, but it would be worth it. And with that, I will see you back here tomorrow. I will start around 9:30, 10 a.m. tomorrow morning. Recap of the afternoon, and until we catch up. So I'm going to send you over to my secret son or secret brother, Valhalla Awaits, who are covering the Karen Reed case. And tell him I said hi. No, thank you for being here. Thank you for allowing me to do this, to try to translate with snark, words, some legal thingies. Thank you. Hug your family, folks. Unless your family is crap, then screw them and give your love to the people who deserve it. Okay? See you tomorrow. Bye-bye.